How you doing?
Hey, Lakeisha.
James, nice to meet
Nice
you.
to meet you.
I never met Miss O'Berry in person. I just seen
I
her through
know,
the.
in real
Oh,
life,
yeah,
yeah.
on that screen.
I
Nice
know,
to meet
really
you.
nice to meet
Yeah.
you in real life.
Thank you for your
Yeah.
service too,
Oh,
helping
well,
us out. and
This is the fun part.
Thank you,
You know,
sir.
all that particular
Right,
details
right.
we do with the
Yeah.
writing the SOPs and working through all that stuff, that's like, I mean, this is the fun part.
That's why you don't see me that much on those parts. No, I'm just kidding.
Yeah, that part was not fun, but it was
No.
necessary and it was.
Yeah.
It was some really good due diligence that your board did. to get
Are
that final
you
product.
based out of Richmond? Are
Uh-huh.
you, okay, so you live in Richmond currently?
Mhm. Well, I live in the suburbs of Richmond and Chesterfield.
Right on, okay.
Mhm.
So say my daughter.
Oh, okay.
So, yeah, which is convenient because we're out there, you know, there's always fun stuff going on in Richmond, festivals and
Mhm.
music events and so.
So we have daughters
Yeah.
the same age then.
Do you?
My daughter is a freshman at Tech.
Oh, okay, right on. How about that?
Yeah,
Yeah, I was watching them last night hoping that they could
Well, they
pull off that
I
win.
know, I was
So
I didn't-
LSU won.
LSU won.
LSU, yeah.
Yeah, I didn't watch it live, but I was, you know, I tuned in like it went online to read how they
Right.
were doing and I was like, oh, they started out strong, I guess, but couldn't hold it.
Yeah, both of the games are really good. I don't know if you saw any of the second one,
I didn't, I was knocked out.
knocked out. Yeah, South Carolina. Of course, they had won 36 straight games. I think 40-something straight games going into last year. You know, being in Charlottesville, people tend to be Dawn Staley fans. I'm a Dawn Staley fan, but tell you what, there was a young lady from Iowa that is phenomenal.
Oh, she is.
She dropped 41 points and she's the best player.
Last night,
Last night,
Wow.
yep. I
this
mean,
year has been such a bracket buster NCAA on
It
both
has
sides.
been.
It's like
mhm.
unbelievable.
Did we go on at 12:30?
The people that are thereabouts,
Okay.
let's put it that way.
I might run to-
All right, no.
Yeah,
let's
it's
see.
Okay, all right.
Bill.
I guess I'll just go on our PCOB page to get to log on. To the Zoom.
Bill,
Yes, oh, sorry.
do you need me to show you how to share audio on Zoom?
I think so. Let me,
Okay, so if you just look up at the big screen really quick, it's super simple. Just click share screen and then
Share
share
sound.
sound.
okay. I'll just log in and give it a shot here, actually.
Do you need the link to the Zoom?
Join webinar.
Is that on the page, the PCOB cover page? Because I'm looking for that link.
I'm not 100% certain you got invited.
I was not. If it was by email, at least not as this morning.
Mr. Miley, the case is submitted. We'll hear argument next to number 87, 65, 71.
It's the use of this device. And
So I got it coming out of mine, not out of.
Are you still, you're still muted, that's why. You have to make sure you're unmuted through Zoom.
And I think the video is muted too.
I need to watch what you're doing because
there's coffee and donuts.
PowerPoint.
Keisha, there's coffee and donuts.
Oh, okay.
Nice to see you. How are you?
Good. How are you?
welcome.
Mr. Miley, the case is submitted. We'll hear argument next to number 87, 65, 71, D. Thorne Graham versus M.S. Connor. Sir, you may proceed whenever you're ready.
Mr. Chief Justice, please the court. On November 12, 1984, Mr. Thorne Graham was not a convict or a criminal. He was not a pretrial detainee. Indeed, he was not even a formal arrestee. He was a free citizen of the United States of America who on that date had an insulin reaction. And he called upon a friend to take him to a
You brought coffee.
Yes.
Brought coffee.
There's one regular living cap. They're marked. There's coffee and donuts.
Way more
Can we-
interested
can I-
in donuts. You can. Some donuts, that sounds like sugar too.
You see how things at Habitat.
Let's see.
Are you doing development there?
I do, I was either community partnership.
Okay.
Yeah, but we have the big Southwood.
I was gonna ask you about South, how it's going.
We
That
have,
is the coolest thing.
it's so cool.
I mean, I've been down there pre and it really.
Yeah.
I mean, some of those towns are just uninhabited.
Yeah, yeah. I was just there yesterday and I was there at the beginning of March and then the end because we had Women Build this month.
Are they doing it in sections?
Yes.
Okay.
Yeah, so we started with building on the property that.
The case is submitted. We'll hear argument next to
You mean empty lots?
Yeah.
Okay.
And then we'll like move people into those homes and then
Chief Justice.
go into the next
Mr. Miley, the
section.
case-
Yeah, to avoid displacement,
How long is it? It's gonna be several years, right?
10 to 15.
Oh, wow.
Yeah, yeah,
Exciting.
exciting, very exciting.
So happy for the residents.
You do. You don't like napkins, however, so.
Can I just use city guest for my internet?
Yeah.
City guest. Don't need a password.
It's free.
Thanks.
I know, I got this one. You got the second one.
So you got that too,
Yeah, I'm just gonna have you stop sharing your screen for now
Sure.
and then go back to muting yourself.
Stop share. Stop share. Okay.
I would also mute yourself so that you're not,
Mhm.
we're not hearing you also over the internal mics.
Thank you.
Sign your agreements.
Oh, you did?
So is this the room where you help the in-person meetings?
Well, such as they've been, we haven't really had many.
I mean, the few that I've.
Yeah.
This will become a tradition.
So that's one of the questions I was meaning to ask you, because I was scouring your ordinances, and under what authority did they write a specific ordinance for boards and commissions for?
They did,
remote?
I didn't get a chance to look it up.
Because I was looking for that, and I know I found the continuity of government.
You mean the broad ordinance for all
Yes.
such bodies? Yeah, there is one somewhere in the bill.
No, it's in the municipal code.
Yeah.
Boards and committees, but they also wrote, they had a, you know, they promulgated a health emergency.
I have that one.
And I believe they revoked the health emergency, and I haven't found that document. I didn't have a chance to look, you know.
Because in my FOIA presentation, I do sort of a high level, but then bring specific issues related to PCOB into it. But there are some remote meeting implications from a recent case that came down from the Virginia Supreme Court that just came down on the 23rd of March. So we as lawyers and as local governments are still trying to get our arms around the impact of that, but it may affect some decision-making that was done sort of during the state of emergency. But we're not really going to get into that today.
Yeah,
but
I mean,
just
I think
kinda-
our plan is that in-person meetings are just highly desirable, and that's kind of the way we go forward.
Where's the city bill now on open meetings? I mean, have they transitioned completely, or are they case by case?
They say in that document that I read, and I cannot find, the basic idea is that we now need to meet in person.
Okay.
And we can not choose to not meet in person up to 3 times a year. And so that's basically.
So when I get to the electronic meetings portion,
This is Stanton County.
it'd be great for you to fill that in, because that would have, I mean, to the extent that there is some structure around that,
14.
that would have come more from sort of conversations and internal meetings, because there's really not a great paper trail for that,
I called your son.
which worries me.
I called your son. There you go.
When you start doing decision making as a board,
I said, thank you for joining the.
then you're really going to have to justify why it was
Updated
electronic
furniture with just
and in person meeting,
Yeah.
in order for those decisions that you make remotely to be
In fact, I was just talking to.
supportable.
Yeah, and I'm just saying,
24 hours.
we have a hearing, it's gonna be a public hearing.
Mhm.
You know,
Jeff Frazier.
folks, we
Welcome. Glad to have you. Jeff.
so.
But there's public versus public in person versus
Yeah, it was
public
good. I saw
electronic.
a picture of us together.
And the Supreme Court of Virginia can't very much down about the difference.
Yeah, all of
That
them.
may be a subtlety. I say.
I saw you.
I want to be
So I congratulated myself for joining
all in favor of face to
And he
face.
said, no, I didn't do that.
If you can
I
possibly
said,
do it.
well.
You know, the issue, as I understand it, is that participate remotely in a person-to-person meeting, now they have
It's
to,
amazing,
even
man.
slightly higher. They have to have a legitimate excuse, and I have to be agreed by.
Right.
powers that be and all that.
Bill, what is the internet we're supposed to use?
City gas.
Phenomenon, right?
Said to my wife, she said, what are you so excited about? I said, nobody. Set up for.
Yep.
Right.
I couldn't believe it. He don't, I mean, I'm telling you. I felt bad for Kenny Brooks. He did good.
Yeah.
Says Wi-Fi not connected.
It did for me for a few seconds, and then it
Give
popped
it some
on.
time. Okay.
There's some talented, strong ladies from the Midwest. She's like, they're not offering the West. I said, let's look at their roster.
I was surprised that
My wife's from Iowa, so she's, yeah.
Kenny had all those white girls. What is that?
Messed up.
I'm telling you.
You made the mistake of doing the diagnostics report, which will take.
She'll be something.
Literally, he's just playing this audio at the very beginning.
Probably
Don told
10 minutes in.
Okay.
Already got a degree in special.
What I'm gonna have review is, so I'm not walking back and forth in the back corner, I'm gonna have you come up to the podium,
You know,
and
that's,
it's on
that's the same.
Chrome, and it's right here.
It's
And I did test it, and it is working,
Okay.
so.
And the volume controls, I just change it or is it? It's okay.
It's all. And also, for any attendees, it's gonna be the same thing, share screen, Chrome, or share screen, sound, Chrome. Okay.
And I
Okay, I'll open up.
have I been promoted to panelist so that I can share screen when my portion comes up?
Yeah,
Just because my boys are.
I'm fine.
Pam,
I'm
nice to meet you. Pam, very nice to meet you. I'm a counselor.
Sunday.
Board.
Bring kids for free on Sunday.
There you go, there you go.
Thank you.
Thursday, Friday, Saturday.
All right, I'm trying to sprawl. I know, right? It's so much stuff. It just- Oh, yes, yes. I have probably more than I need. For a little person, I
The robots.
always take up more space than I need.
I have a coworker like that. She's the smallest person,
Yep.
and she'll take up the whole table.
And see, for me, I know why
I'll
that
send
is.
you all the
I was
information.
the baby of 5,
Time and all
Oh.
and so I was always fighting
Mhm.
for my little corner of the world, and so when I get one,
And if they talk us.
You know, I stretch out. That's why I eat more than you would think for a one person, and I take up more space. Because I'm always the runt of the litter fighting to get my fair share. So you should ask that coworker.
I will.
If
I'm
she's
gonna
a
ask her. Be like, is this stemming from your childhood?
Everything comes from that, right?
Swimming. What is the problem? Oh, I thought you would get over there.
So Lakeisha, how did you get interested in PCOB?
It's, my background is mental health. So I went to school and, I have a master's in forensic psych.
yeah, a little less
But
than a year.
when COVID hit, I left the mental health world, but didn't really want to like leave my involvement
I don't know
with
about
like that population.
That was around on the
And so
side.
then I was like, what can I do like that isn't work related, where I don't have to go in 40 hours a week and commit to
They
that.
are.
So I started looking at volunteering.
Mics in this
And
room.
then I was like, I would love to serve on a board. And then this came about.
Someone with the mental health background is really, really helpful to this kind of board.
Board members know that too.
Spread the word.
And so much of police interactions comes from,
Yeah.
you know, from
Yeah.
mental health crises. Just like the unfortunate case in Henrico that we
Yes.
just had.
Yeah.
The guy was
So
having a mental health crisis and the response was, he's gone now.
Yeah.
And Susan, are you the member that Bill told me who's a former prosecutor?
Yes, in New York.
Now, how long?
I did about 17 years in New York City.
Really? In which DA's office?
So I was hired by the Manhattan District Attorney's Office under Robert Morgenthau, but I was assigned for most of my career, not all of it, but most of it, to the Office of Special Narcotics, which had jurisdiction throughout the 5 boroughs.
Oh, wow.
So
So
I did it for
I'll
both.
be back.
Oh, okay, okay.
And you said 17 years you did that?
17 years, and then when I finished, I was chief of the investigations unit, which did the big drug cases, like the wiretapping cases.
This, my friends, is walking order.
Yes, I like.
Well, now I run an art park, so I'm at the clear at the other end of the
So, yeah, I would have I would think your brain needs to rest some.
Yeah.
It was kind of-
Needed a little
I was a prosecutor for 8 years, but
Where?
that was in Richmond, Virginia.
Man,
I did love
I'm
it.
trying to get slim and trim like
That
you
was the
guys.
best job I ever had,
Yeah.
for sure.
And Mr. Morgenthau, Robert Morgenthau was just this incredible human being.
Yeah.
It was an honor not just to work under him, but just to know him, which is really something special.
And I heard a podcast
He taught you how to do it the right way.
a couple of years ago that profiled him, and it did just sound like
Give you more info, you give me more info later.
Really
There's nothing bad,
balanced
but, you know,
that
was so
role very
balanced,
well.
and you know, politics
Put him in touch
didn't
with-
Get a
affect
picture for your
him at all.
grandkids here.
He
in
did
your,
what he thought was right.
We
And
get a picture for your son and grandkids. that
That's
we
There's
not
a
always the
story.
case in prosecutors' office.
Legendary right here.
because
Mr.
oftentimes
Fleming.
it becomes a very political position.
Good one.
And oftentimes
Let me see
the
here.
elected official keeps a heavy thumb
Major
on
Charles.
discretion.
There's a
and
story
outcomes.
about Mr. Morgenthau from his early days when he first was assigned. He was, their family was very close families with the Kennedys. And there's a story about a friend of the Kennedys that was arrested. And the whole Kennedy family came to Mr. Morgenthau and said, look, you know, he committed a crime, but he's a good guy. You really shouldn't do anything with this. And I think if I remember right, it might have been a sexual crime, but I can't, don't hold me to that piece. And they said, really, you know, it would be best for the country and for our citizens if you would not do this. The next day, he had him indicted. And the Kennedys were like his best friends. But he's like, you have to understand that that's not how this office is going to work. And it kind of set the
You mean
stage.
equal
for-
justice under law?
Yeah.
What an
Right?
odd concept.
Justice without fear or favor?
Now,
And it did set the stage. They left him alone after that. It's just
Yeah,
like, okay,
as I
we're
watched
gonna-
this whole Trump indictment thing play out, I'm like, did we have this conversation about any other
Mr.
person
Bragg.
being charged with a crime? We
Yeah.
don't have this conversation about.
Because when you and
any
I
other
talked,
being
I don't know
charged
that
with
this
a
is a
crime.
wise case.
Okay,
Why
yeah, I
should
know.
we-
A
why
lot of
is-
people have said that.
do we
Yeah.
have
And I haven't
conversation
studied
with
it enough,
Trump?
so I don't feel like I'm really
No one
able
else
to,
gets.
like,
some
I haven't read the
benefits and-
indictment and I
Well,
haven't.
Well,
it's marketing for them,
it's not
right?
the best case, or they should have brought it
Until he's
later.
arraigned, it'll be
Yeah.
really hard.
When you
They
get
still-
ours.
But it was my office that
Who's
did it.
ready to go
Much
and-
broader than
and
Stormy Daniels. There's
Nobody
30
asked
counts apparently in
when
the.
somebody
Well,
was
but
charged
that
with
could
stealing
easily be,
bags.
I don't know,
That's
but that
how
can
that
easily
can
be like if he made
hello?
six
And Rikers were-
$10,000 payments at
I think we're
16
on,
charges. Oh, so.
I think our sound is
that's a little-
being recorded too.
order, yes.
Sorry.
I guess we should get started.
Patricia will be right back. She said she just needed to go get some water.
Okay.
But you're bringing us water with your donuts.
He brought you
So,
caffeine.
yeah,
He brought
this
you
is,
caffeine.
We're all hyped up.
From the city.
PCOB for the last couple of years.
So the special training session of the PCOB on April 1st is now called to order. This is our sort of agenda, which is extremely flexible. We're going to be opening with Graham versus Connor, which is a very rich case with a lot of relevance to the kinds of issues that the board will be addressing. I'll go quickly over the powers of responsibility and talk about what has happened in the way of complaints and what our workload might be over the next few years. I've got and then a break, or actually we could have a break anytime in between the topics. And Ms. O'Barry will then talk to us about the requirements of FOIA and sort of the issues associated with the conflicting requirements of openness on the one hand and confidentiality on the other when it comes to the board's functioning. And then I'm going to make your eyes glaze over, absolutely 100%, showing you some pretty complicated flow charts of our more complicated functions, complaint processing, review hearings, and so on. And then questions and next steps. We also have, as is required by law, have a public comment period at the end. So let me start with a quick introduction here. That one. start here. See if I can get it. There we go. So why do we need to be here today on a beautiful day? I was really hoping it would keep raining. First requirement is this statutory requirement that we have to complete 8 hours of training for all new members within 3 months. I don't care about how many hours you spend. What I'm concerned with is that you become knowledgeable about the issues that you need to know on. In a few months, we are quite likely that we'll be asked to be making decisions about review requests and investigations of citizen complaints. And so we kind of need to know what we're doing. On the one hand, we need to know sort of the basic laws and the parameters within which the board operates. On the other hand, we're not all going to be subject matter experts on every aspect of police oversight, although we now have some lawyers, and that's going to be very helpful. At the end of the presentation today, I'll talk about I'll make some recommendations about where we go from here in terms of training, and most of that is sort of self-paced. Webinars put out by Nate Call and articles published in the literature. So that's it. Any questions before we start? Okay, so I'm going to start with this is with Graham versus Connor. You'll hear this case over and over again mentioned in the course of talking about police oversight. There are a number of other leading cases that we'll be touching on briefly in other sessions. It's both about law and about the human impact of police encounters that go wrong. And I'd like you to consider as we go through the actual arguments in the case and the outcomes, how could things have been made happen differently? What could a review function? So start with, if I can figure out how to do it. And I can't figure out how to do it.
I got you. You can sit down, Bill.
Okay, sure. Sorry. So we're going to start with the first 4 minutes of the oral arguments in the actual Supreme Court trial, which there's a lot of lawyerly rhetoric, but it really lays out very much the issues that are at stake. And if you read the case,
This is submitted. We'll hear argument next to number 876571, D. Thorne Graham versus M.S. Connor. Sir, you may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. On November 12, 1984, Thorne Graham was not a convict or a criminal. He was not a pretrial detainee. Indeed, he was not even a formal arrestee. He was a free citizen of the United States of America who on that date had an insulin reaction. And he called upon a friend to take him to a convenience store where he could purchase some orange juice to help counteract the effect of the insulin reaction. Upon arriving there, he noted that because of a line, it would take him a long time to get his orange juice. He became concerned and ran to his friend's car and motioned for him to take him to his girlfriend's house. A Charlotte, North Carolina police officer saw him hurriedly exit the convenience store and determined the conditions to be suspicious enough to allow for a brief investigative stop to determine the facts. Upon making this stop, Mr. Berry immediately informed Officer Connor that Mr. Graham was indeed suffering from what he described as a sugar reaction. At this time, Officer Connor asked Mr. Berry or told Mr. Berry that he must remain with Mr. Graham at that time while he determined what happened at the convenience store, and he began to depart. This time the petitioner became concerned, and according to his testimony, he has little memory of what occurred, most likely because of the continuation of his insulin reaction. He exited the car and ran around it twice, and then sat down on the curb. From this point forward, taking the evidence in the light most favorable to the petitioner, as must be done on a directed verdict, he was seated at that time, again peacefully talking with the police officers when backup officers arrived. We know that those officers must have been told of the alleged sugar reaction before the first comment.
Doing when the officers arrived? He was sitting on the curb.
Sitting on the curb.
Was he conscious?
Yes, he was at that time.
Had he been?
Yes, he had been conscious, but he has no memory of those events.
To whom was he talking?
He was talking to Mr. Berry and to Officer Connor at that time when the backup officers arrived. And we can tell by the comment of the first arriving officer that they were explained about this sugar reaction, because the first comment was, "I've seen a lot of people with sugar diabetes before, but none that ever act like this. He must be drunk. Let's lock him up." And they grabbed him, and they turned him over, and they handcuffed him very tightly. So tightly that at the conclusion of this episode, he had cut wrists. And they lifted him up by his arms, and they carried him to the hood of Mr. Berry's car and laid him over it. At this time, he regained his senses and began to talk with the officers and complain about the treatment he was receiving, and he asked them to please check his back pocket for his diabetic decal to show that he was indeed a diabetic. The response was an officer told him to shut up and slammed his head into the hood of a police car, Mr. Berry's car. A few moments later, no less than 4 police officers grabbed Mr. Graham, one on each arm, one on each leg, picked him physically off the ground, carried him to a police car, opened the back door, and threw him in, to use the petitioner's words, like he was a sack of potatoes. And they drove him home, never arrested him. And when he arrived home, they unhandcuffed him, and he fell flat on the ground. And he was carried within a few moments for medical attention, and an examining physician discovered he had a broken foot. He in fact had an insulin reaction. His blood sugar count was very low. And they discovered that he had cut wrists, and he had a large abrasion over his right eye. He had an injured right shoulder that prohibited him to the extent that for 2 weeks he could not administer his own insulin shots. He missed 5.5 weeks of work with the North Carolina Department of Transportation. He incurred medical expenses, all as a result of this. On these facts, the lower courts on directed verdict held that these acts by the...
Okay, so that's sort of the fact pattern. Now, the lawyer's view from Ms. O'Barry.
Well, thank you. So as I was revisiting Graham versus Connor, of course, I was a prosecutor for 8 years in the city of Richmond in the 90s. I was a judge for 12 years in Chesterfield from 2009 till 2020-ish or so. Graham versus Connor was not a case, believe it or not, that came very much to my attention. I obviously had studied it, was aware of it. It came before I went to law school. I graduated law school in '93, so it was one of the foundational cases. But it's not a case in everyday criminal jurisprudence that you visit unless you deal specifically with excessive force on the civil liability side. So I was revisiting Graham versus Connor, and I was remembering my first reaction to Graham versus Connor when I was in law school, thinking, well, it doesn't seem very much like the human element was at all a part of the decision-making here. This was one of those cases, very much as happens when cases get all the way to the Supreme Court, where the human portion of it is completely removed from the decision-making. So Mr. Graham's human insulin reaction, how he was treated, the level of force that was used. Even when you read the case, they summarize it, but they don't talk about that very much. It's very much procedural decisions being made. So when Mr. Graham was, filed his case for a civil rights violation, through 2 levels of court, he did not prevail. And his case was considered under what was the 14th Amendment under a due process claim. 14th Amendment is one of those that sort of catch-all, inherent rights, equal protection, all the places that I believe, just probably shouldn't talk about what I believe, but where some of the cases that are more favorable to people who don't have particularized interests get decided. That's where Roe versus Wade was decided. That's where the gay marriage case was decided. That's where interracial marriage cases was decided. It's one of those sort of inherent rights clauses, the 14th Amendment. So whenever there's not something specifically in one of the other amendments that are specifically enumerated under the Constitution, they look to the 14th Amendment to say due process. Was a person, can we find a right in this sort of collective inherent rights amendment called the 14th Amendment? So under that, basically saying a person has a right to be free from excessive force is how it was analyzed on the first 2 levels of court. Mr. Graham didn't win. He didn't win in either of those settings. So he appealed the findings of his case to the Supreme Court. And in the process of appealing it, sort of the due process claim fell away, and the Supreme Court said, well, let's consider whether due process was, the 14th Amendment was the right place to consider this case, the right amendment to consider this case. I won't bore you with sort of the legal mumbo jumbo because probably nobody cares but Susan and I. But the Supreme Court ended up saying, well, no, it's not a due process claim after all. The 14th Amendment is not the right amendment to analyze these kind of excessive force claims because it should be analyzed as a 4th Amendment claim because there is a specific right that is protected under the 4th Amendment, which is the right to be free from unreasonable seizures of your person. So because this was a case of seizure, well, I think it's kind of the seizure in and of itself, was not problematic. This is one of those cases where they sort of analyze the seizure and they sort of buttonhole the use of force sort of with the seizure. And they say that because there is a 4th Amendment right to be free from unreasonable seizures, we should analyze it under the 4th Amendment. And they totally push aside the 14th Amendment, which would have required that we look at what an officer is thinking, all of those subjective things that an officer is thinking and why they made decisions based on what the officer was thinking. They said, no, that's not the standard. The standard is 4th Amendment reasonableness. And so when they say 4th Amendment reasonableness, then they overlay sort of, they just overlay it, the objective reasonableness. What would a reasonable officer in the position of with knowing these facts, how would they have acted and what would they have done? And it's really, the unique thing here is they really spend a lot of time talking about the reasonableness of the seizure. I don't think anybody would disagree that the officer had some right to make what's called a Terry stop and investigate sort of this, hey, ran in the store, ran out. I think it's probably still fishy. Even then it's very tenuous because who doesn't, that's just kind of a common occurrence, right? But more justifiable. But here they go from that and then so you hear what the lawyer just said about how at the time that the real force was used, Graham had run around the car twice, didn't run away from the scene, didn't run towards the officer, ran around the car twice and sat on the ground. And by the time the other officers came that actually applied what was the excessive force, he was seated, he was calm, he was talking, he was not fleeing, he was not presenting any danger. The court kind of really moved away from that, didn't really kind of assess that in their grand analysis. And what they did is they came up with what they call reasonableness factors to be considered in these matters. And the reasonableness factors to be considered are considered for deciding whether the application of force was appropriate. And they said three things: that the office, that the fact finders should look at what the severity of the crime at issue was. Well, what was the severity of the crime here? There was no crime. Whether the suspect poses an immediate threat to the safety of officers or others. We know from this fact pattern that by the time the officers who actually applied the excessive force came, he had posed no immediate threat to the safety of others, or whether the suspect is actively resisting or attempting to flee. Nothing in this fact pattern implicates any of those things. So what the Supreme Court, they laid out this test, that this will now be the test by which we will judge whether or not an officer has used excessive force or not. And so the very interesting thing here is people think Graham versus Connor stands for the fact that the Supreme Court said that these officers acted reasonably, objectively reasonably. They really didn't. They just said, this is what the test will be. Now we're sending it back to the lower court. The lower court apply this test and do whatever the outcome, and find the outcome that should be found. It was really when it went back to the lower court that, they said, oh, sure, yeah. All the facts here meet this test. Mr. Graham, we throw your case out.
Yep.
So the Supreme Court really, in these kind of cases, they're in the business of setting a standard, establishing a test. And for the most part, they're going to, unless there are sometimes cases where the facts are really clear and they apply the facts in establishing the test. For the most part, they set out what the standards are and they send it back to the lower court and the lower court sorts it out. But Graham versus Connor is a case that is still highly disputed. Police officers, and I've done police training for many years. Every police officer can tell you Graham versus Connor. They can tell you how to write their reports based on Graham versus Connor standards. So as a body that will be deciding what police actions are legitimate or are not legitimate, you really do need to study Graham versus Connor, study what the court said about that the standard is whether a reasonable officer under the circumstances, having the totality of information that the officers had then, would have made the decisions and the choices that were made in this case. That is the standard that is going to decide whether there was excessive force or not. In my view, if you apply that test to these Graham versus Connor facts, the conclusion should be clear. Mr. Graham should have been found to have had his rights violated through excessive force. But that's not what this court did. The court set out the test. They threw out the 14th Amendment. They said Fourth Amendment objectively reasonable standard is the one that is to be used to decide excessive force. We can get into a little more of the particulars of the case, but that's sort of the overview of the getting away from the 14th Amendment review to the Fourth Amendment objectively reasonable standard, a reasonable officer, subjectively reasonable actions by an officer, given what the officer knows at the time, not 2020. They talk about 2020 hindsight is not a part of this. So whatever the officer found out later, doesn't matter how unreasonable it becomes with the information they know later. It's what the officer knew at the time that they made the choices. So that's high level, and we can certainly get into the nuts and bolts a little bit more.
Would you clarify one thing, Pam? Is reasonableness from my perspective as the defendant or plaintiff, or is it reasonableness from the point of view of the officers?
A reasonable officer, and it is not, was it reasonable what that officer did at that moment? It is an objectively a reasonable officer under the circumstances. Okay. So the challenge
doesn't matter whether I think it's reasonable.
Doesn't matter whether you think it's reasonable. It doesn't matter what you think in looking back at the factors. What matters is would a reasonable officer in that officer's circumstances have made the same choices or would have had the right to make the same choices? That is the standard. And really, I think the goal over the years of jurisprudence since this is to frame what is a reasonable officer.
Yeah, I've been wondering.
And
Yeah.
a body such as yours can help establish what is a reasonable officer in Charlottesville, right? Because based on what the training is, based on what policy says, based on what standards are set, that reasonableness standard can be customized to certain jurisdictions based on policy, training, supervision, oversight, and all of those things. So you all have a really important role in sort of making Graham versus Connor better than it was, because you can help influence what a reasonable Charlottesville officer should or should not do in certain circumstances.
I remember hearing that a lot in the George Floyd trial. He kept saying a reasonable officer would do this, and a reasonable officer, and I kept thinking to myself, ideally, they wouldn't be employed anymore, right, by this police department if they were not considered reasonable. So I've been kind of playing with that terminology, myself when I've heard it some other times, because I'm like, well, does somebody become? So if you're responding to something, I've thought to myself, okay, if they saw something traumatic happen within a minute of that, right? Like somebody gets shot and then they, act a certain way towards the person that may have shot them or the people that they were with. If they became very violent with what they just saw make them unreasonable because, or is it, so that whole reasonable thing is kind of bounced around in my head a few times
It's a
too.
moving target, and it always is. That's
Yeah.
why all of these cases are always debated and mostly litigated, because, most of the police excessive force, the truly terrible excessive force cases get settled. And there really is not a great body of law of these cases that are rising to challenge Graham versus Connor, because if it's truly horrible, like George Floyd, like Philando Castile, all of those other cases, those settle. Nobody
It never
wants,
makes it up.
police organizations have
Right.
zero interest in seeing those bad law cases go up and confront this great precedent that they have in Graham versus Connor.
Just a couple of points I want to emphasize. One is that when the Supreme Court set the standards and remanded it, it went back to the same court and they said, oh, no, short court, because policeman was personally reasonable. Again, second thing, there was never any discussion of potential criminal charges against the police officer. I have spoken to one of the attorneys involved in the case, and as far as he knew, there was no police discipline that arose from the case. And Mr. Graham got nothing for his,
And years of litigation is what he got, which,
and there's one other
and
thing.
that is no small thing.
Yeah, and there's one other thing, and that is, did anyone hear the word race mentioned in this case at all?
No, and you know what I had to do, because I couldn't remember from law school, I had to go and Google
Yeah.
I was gonna do that too.
Mr. Graham to see his face. And of course, he is an African-American man. But he was 39 years old at the time. So, was not some sort of young.
And
not
he
so young to me.
was small and slightly built, apparently, so it was not like he was a great
Well,
threat.
and if you think about Graham versus Connor, another point that gets lost sort of in the discussion is this was a unanimous decision of the Supreme Court. And this was a Supreme Court where Thurgood Marshall was still sitting on the court. This was Brennan. Who did we have then? We had
Saturday O'Connor.
Rehnquist wrote it. We had Scalia and O'Connor and Rehnquist, which were the hard conservatives on the court. Kennedy, who at that time was still more conservative, but later became sort of a more centrist swing vote voter. Blackmun, who was a Republican appointed justice, but later in his later years sort of sort of voted more with the liberal, what was considered the liberal wing of the court. And I hate to even talk about the Supreme Court that way, but that is the reality that it has become sort of a liberal versus conservative. But yeah, this was by no means like today's Supreme Court where it was overwhelmingly a conservative court. This was probably an evenly split in terms of philosophy. And even Thurgood Marshall concurred in the decision. Of course, I think probably knowing how it has been used over the years, Thurgood Marshall, I'm sure, if he could have a mulligan on this one, he and Brennan and some others would probably rethink it because it has really been, it's been used to the advantage of poor policing, in my opinion.
Yeah, I
So,
mean, the idea of not second guessing.
right.
I mean, it's so, that means that police can have a very wide latitude in terms of what they think is reasonable, and they may have been blind with rage.
Well, and
but-
that's another thing. You could have an officer even, and it's the case very explicitly says, even an officer with bad intentions, even if an officer goes into the case, into a situation and uses excessive force, and we know that the officer, say it was a transgender victim, and he has posted that he hated transgender people and he was going to go after transgender people, and anytime he saw a transgender person, he was, I mean, this is just hypothetically speaking. Even if you know that officer that is charged with excessive force went into this confrontation with a transgender person and used excessive force against a transgender person, none of his ill intent, none of his ill will, none of that can be considered in the case. It just cannot be considered unless, of course, there are facts to say as he's using the excessive force, he's saying that. Of course, that is a factor that you will consider just in terms of, what happened. But the case very explicitly says we don't look at the subjective intent of the officer, not at all. You don't. We objectively remove ourselves from whatever that officer was thinking at the time and try to say, would a reasonable officer in this officer's position have acted in this way? And if so, there is no violation.
Yeah, I should point out though, again, one of the things that we're going to talk about innumerable times is that the board's authority is to render decisions related to standing orders, general orders of the police department. And there's a general order on bias-based policing. So that is an avenue whereby that kind of consideration can be brought in. Although we think that the current bias-based policing order is poorly written, but still. So I'd like to, before we end up here, think about sort of an ideal world, what would have happened.
Okay, just a
Yeah, go
question.
ahead,
Does this sort of imply that we then have license to determine reasonableness from our vantage point and when a case is presented, Pam?
Well, your vantage point is going to be a different one than a court would
Right.
have when it's trying to decide what was excessive force for a civil rights violation. You can look at, again, as Bill said, you'll be looking at policy, you'll be looking at training, you'll be looking at supervision, you'll be looking at all of those things, and you can say, you're not bound by that sort of Graham versus Connor versus saying specifically whether it was excessive force. You can say, this violated the policy of the Charlottesville Police Department, or it did not violate the policy of the Charlottesville Police Department, but it should have. Therefore, there should be a policy in place that would make this kind of behavior inappropriate or wrong, and then you affect the policymaking side or the training side of the police department.
But at the ground level, if we have a case where excessive force is alleged, it seems to me we would render an opinion on that.
Oh, absolutely, you would. And you would have to, you're going to hear the Graham versus Connor sort of standards being articulated. You will, just as a prosecutor, and I'm sure Susan could probably speak to this as well, you know, when you read a police report and, you know, every prosecutor knows the officers that do it right. And they know the officers that are gonna fudge, right? You're always in the back of your mind, you know who's gonna do what. And sometimes when you had that officer that you kind of knew, oh, they're always gonna fudge, you could read a report and you could see them ticking off all the things that they needed to say in order to meet a standard. So that happens in just sort of supporting a charge for a case. So of course it happens on the civil liability side where, you know, their livelihood and the city's livelihood is at risk.
Yeah,
That
but
happens.
again, an important point here is that if someone sues the city, we're out of it.
Right.
If they allege a civil rights violation in court, then
Goes to the city attorney.
the city attorney decides whether we can investigate in parallel. But the civil part of it is not us. I do not make people whole. We cannot make financial awards. We can denounce, that's what we can do. We can say we can make preponderance of evidence findings that this was in fact a bias-based act by the police and so on.
Considering the bias-based piece, could we as a board, based on the case, suggest specific training? Or is that out of our?
No, absolutely. You can, that is sort of one of the, and Bill and I sort of found this as we were spending the months and months writing the SOPs, the standard operating procedures for the board. We, I think at some point had a conversation and we were like, you know, the ability to impact policymaking is, and the auditing function is one of the biggest powers you have, right? So you could, without even a representative case, just in your auditing policies and procedure function, say, wow, you know, I'm thinking about Graham versus Connor, and this seems to, your policy seems to set up a situation where officers can do things that we don't want them to do under the cloak of Graham versus Connor. So we want to affect policy and training, right? Policy, training, supervision. Those are sort of the foundational ways that police officers show up in the community, right? Based on the policy that they have, the training they have, and the supervision that they have. This board has the ability to impact that because you've been authorized by the city council to do so. You have the support of the city manager to do so. And I know at least now you have a police chief that I know you all are working to build that great relationship with, to have those conversations about how to affect policy, training, and supervision.
Yeah, and I'd just point out that James and I are also, there's another issue to that, and that is recruitment.
Yes.
And James and I have participated in the interview of potential patrol officers.
Wow.
And so we get to, you know, ask the questions and look the people in the eye and you know, and that's been a very informative for us. For me, very reassuring that the bunch of primarily young people who we're seeing, you know, seem to have their heads in the right place and be willing to serve. So.
And that's a huge impact to have, and not only to sit in the recruitment interviews, but to affect the recruitment policy. Like, where are you seeking recruits? Where are you finding recruits? I used to be general counsel to a couple of chiefs of police, and one of the things that the chief that I've always loved working with used to say about recruitment is, we don't just want army boots, people with army boots and sneakers around our table from police. We want people with wingtips. We want people with, you know, from all kinds of backgrounds to be our police officers, because we don't just want those coming out of the military or those who just have always had a desire to be a cop. We want people who are, you know, people who bring other skills, soft skills, hard skills, mental health experts. All of those people are the people we want to see in the uniforms. So.
Yeah, you know, I will say, one of the great things that's come out of this board and some changes we're seeing with the police department is that we were able to participate in interviews, which is why I'm gonna leave a little early today. I was going all last Saturday. My family's like, yo, and my buddy, Freddie Jackson, who runs a nonprofit, Love No Ego, African-American gentleman, highly respected in the community. He also was able to take part in the interviews. Last Saturday, we interviewed about 16 people. My group did 8, and then the one that Freddie was on, had 8 different folks. And I can't say so much about who we interviewed, but it wasn't very diverse, compared to what I've seen in Charlottesville in terms of who has been on the force historically. It was a pretty diverse set of, like Bill said, fairly young people, early 20s, late 20s, very talented folks. And we'll see who ends up being hired. It sounds like, though, if you interview about 30 people, you might get 5 or 6 because, they still have to go through the background checks. They still have to want to do it. And the younger generation, and the physical fitness element of it. And I think the young generation too, sometimes is like,
Well, and we want to be selective also.
Right, and you want to be
We want to get
selective.
high quality folks,
And there were some folks that, when you asked the questions and the way they answered, again, I can't give details, but you said, okay, this may not be a good fit for you. And I was once one who thought if you came out of the military, because I've worked in that arena, that, that might be a good transition. But as I've learned from being on this board for almost, 3 years or about 3 years, that for everybody that doesn't fit 1-to-1, right? So, yeah, I think we got to see some good, well-rounded, people. And so we'll see. I think they're going to have to probably do more hiring events because I think they're short about 30, 35.
Almost 40.
Yeah, officers. And I doubt that the 2 events that we were part of are going to produce enough, staff. So y'all will probably get opportunities, I'm assuming, I can't guarantee, if you'd like to participate in interviews as well, so.
And then they can't
Yeah.
start an academy class until they have enough people
Right.
to fill it. And so sometimes in the waiting to fill a class, they lose people. So it becomes one of those kind of problems, like, okay, it would be 6 months before we can start a class because we need to put 20 in the class and we only have 10. And so while you're waiting to get those extra 10, you might
They may drop
lose
in.
2.
Mhm.
So.
Before I'm sorry, you go, because you've been waiting.
No, it's fine. I was just gonna say that, in any investigative process, there's 2 pieces to it. There's your fact-finding piece, and then there's your application of the facts to the law as it's stated. And so as I read Graham versus Connor, I personally am not sure that the law was incorrect, but perhaps the application of the facts to the law. And I think as we take on these cases, I think that's what you're going to find the breakdown often happens, not in what the law says or what the facts say, it's on how you apply those facts to the law. And I think if we're going to be a really effective civilian oversight board, part of our job is to bridge the gap that exists between the police department and the public.
Yeah.
And so our understanding of the police department and what they go through on their job is really important. In the same way, it's important that those police officers start to understand what it's like for the man on the street, the man or woman on the street. And I think that if we do our job well, we can help to create a little better understanding of both sides so that perhaps the breakdown of applying facts to the law will not be quite such a wide river.
Yeah, Reverend, did you want to say something?
I was thinking when I read this about assessments, and are there any, will there be or have there been assessment tools used before, like as someone applies, the pool that's selected to be interviewed? Are assessment tools then given to determine the mental health?
I don't know the tools that this police department uses, but I know that most police departments have assessment screening tools. They do psychological screenings, they do social history type screenings, they do those kind of things just to see if there are any red flags. None of them are like definitive, like, okay, if this pops up, you can't.
Right.
Sometimes if it's a big red flag, but
For temperament, person.
I don't know, maybe James can speak more to that, but I know that is a common recruitment sort of part of the process.
As I understand it, you do the physical, so you're making sure you're physically capable of doing the minimum, get interviewed, and then the background and the psychological evaluation occur. I don't know exactly what the psychological evaluation is, but they do that.
Yeah, they have scenario questions when you interview too. Like, and I guess I'm allowed to say this because it doesn't talk about any person and, individual. I'm not an HR guru, but there's a question, there's several questions that kind of put the interviewees into a scenario and you kind of evaluate what they would do. And so there's one that says, okay, you're at the gas station with your family in the car, you're pumping gas, you look into the store, convenience store, and you see somebody robbing the store at gunpoint, as a cashier at the gunpoint. What do? You're off duty, you don't have any weapon, you don't have anything that identifies that you're a police officer. What do you do? And it was more or less recommended that
Probably shouldn't talk about
candidates
it.
that say, hey,
Just in case potential recruits.
Right.
You don't want to give them a positive.
Oh, that's true.
A good outcome answer. And let
That's
them
true,
start
too.
posing a good answer.
That's true.
But it's
If they're watching.
Let's just,
25-years watching this on a Saturday.
Or
But,
it's recorded.
let's just say
You never know.
some of the answers were rather reckless.
Yeah, but,
And so,
right,
Yeah, wow.
some of the answers on that.
I can.
yeah, and then-
Rambo to the rescue.
Something safe that makes common sense.
Put that big S on their chest.
Yeah. It was stuff like that.
Yeah, that's-
So any other observations about Graham versus Connor before we move on? I mean, I think what it exposes to me is that all of the holes in the law where justice kind of gets lost. And how things could have turned out better if policemen had been inherently more empathetic, better trained, or better supervised, or if there had been an oversight organization that the policemen knew would be watching. So.
Did that happen in the 80s, early 80s?
84, yeah, but by the time we got to Supreme Court, it was like 89.
Long before cell phones, because as you were saying that,
Yeah.
a lot of these get settled nowadays. And I think the cell phone is the main reason,
Yeah.
right? Like we saw George Floyd and the event in Minneapolis and many others. So, if there was no cell phone footage.
Yeah, I want to make a footnote, which is perhaps not so positive, and that is that in early 2021, a young black man on the streets of Charlottesville was bent over the hood of his car retching. And within 2.5 minutes, he was on the ground with 2 police on his back. He was having a bad reaction to some antibiotics. And so the same issue of, how do you respond and how do you treat people with dignity? And how are you trained? How are you disciplined? It's still here. It's 30 years later. Okay. So let me move on a little bit here. See if I can, I just want to go very, very briefly. It's going to be a little dry. Going over the powers and responsibility that you have taken on as board members. Most of this comes from the section 2-452 of the ordinance, which I ask you to read. We are allowed to do independent investigations of citizen complaints. That means that we employ an investigative model. And we will have it, when we have an executive director, he or she will be responsible for managing those investigations. We also don't have to wait for a complaint. If the executive director or any member of the board becomes aware of an incident that involves serious misconduct, which is defined in the ordinance, the executive director can advise us that he or she wants to do an investigation. We can do that. So we can do that on our own initiative. We don't have to respond quickly. We can recommend disciplinary actions if we do an investigation, if we have a hearing, if we make a finding based on the preponderance of evidence that misconduct occurred and that misconduct was serious. We can make a public recommendation to the chief of police regarding discipline. We'll talk about that in a while. Basically, the chief can accept our recommendation or explain why he did not. As we pointed out, we can make recommendations related to policies and practices, and we can review investigations undertaken by the board. So these are, as we'll see, an individual who has had an internal affairs investigation and they're unsatisfied with it. They can file a review request with us, and then we can review that investigation, having access to all of these files, and agree, disagree, or recommend additional investigation. We can hold hearings, and if we cannot obtain information after good faith efforts, we can, by a 2/3 vote of the board, direct the executive director to request subpoena in circuit court. We are required to engage in public outreach, which is an area where we haven't been all that effective. And I have some reason that I'll share some more thoughts later. And there's this wide open clause about undertaking other duties as necessary, which I don't know how that got in there because it's so wide open. In addition, and here this is perhaps our most important function, which is the executive director may monitor internal affairs investigations while they're going on. And we found when Hansel was here that this made a big difference. The quality of the closure letters that came out became much higher. And so when our new executive director comes, hopefully that tradition will be carried on. We also may have full access to evidence reports, files that are necessary for us to do our job. This is unprecedented in Charlottesville. We had a run up to one hearing, which it took for interesting reasons did not occur, in which our board actually saw all of the body worn camera footage, saw the interview of the incident, saw the interview with the policeman who was involved, saw the internal affairs report. That's never happened before in Charlottesville. So that's another tradition we're going to keep working on. And we can establish and conduct mediation programs. And in the case, where we're talking about people who are not being treated as human beings, it seems to me that at least sort of on an idealistic level, a mediation program would be very much a way that we can address these complaints. I know one of our members is very interested in working on mediation, and I hope she follows up. One of our previous board members was a worked with the Lawyers Guild, who was a monitor for police behavior at peaceable demonstrations. And so we now got that as a power also. Things we can't do. Complaints have to be, interview requests have to be timely. And there are certain certain other matters that we can't deal with, like financial management and some other internal city issues. We get access to information, but not if has to be held confidential under Virginia law. We can't investigate criminal complaints against officers. That's out of our job. If our executive director finds potential criminal activity associated with a complaint or an incident, he or she must stop the investigation and tell us, Commonwealth's attorney. We can't compel statements from police officers. However, we have sort of an indirect mechanism that part of the good faith efforts would be to go through the police chief, go through the city manager. And so if the officer does not want to cooperate, the officer could be held accountable as appropriate. And the other thing that a lot of people don't understand is we don't award compensation. We don't make people whole. I've had a noted civil rights attorney in Charlottesville give me an incredibly hard time because we don't have any power. We don't do anything. That's true. We don't make people whole. We don't. That's one thing that we have to explain to people, is that we are more in terms, our job is more to correct police behavior exposed, after it's occurred. And so gradually move toward the future where the policing becomes better and better.
And Bill, can I just interject there? And I think it's an important, helpful thing for you to say to those folks is the enabling statute.
Yeah.
From the Virginia legislature.
Yeah.
Did not give you those powers. It's not a power that you have that you're just shirking away from. We don't want to exercise that power. The enabling statute does not give you that power, nor does anything in the ordinance attempt to move you closer to that.
But I'm gonna guess, correct me if I'm wrong, that whatever determination we make may be helpful to that complainant in a future civil.
Yeah, we have it is.
That's interesting.
So we have
That was a question, I guess, more than a statement, but.
Yeah, there's some interesting wording in our ordinance about someone investigate criminal matter or something that is the subject of a pending civil litigation, and there apparently pending civil litigation has a very precise meaning. Actually, someone's actually filed paper.
I think Susan's talking about getting an outcome here and then taking that to a civil.
Well, no, I understand.
I mean, I think that can be done.
Well, there's nothing in the PCOB's powers that says if you pursue this, you cannot pursue an alternative, whether criminal or civil.
Right, and I think in a civil case, when someone has a civil case, I would think that they can bring it to the court or the jury's attention that this officer lost a case before or was disciplinary action was recommended by a civilian.
See, I would think
that, I don't know.
I would think that a smart plaintiff would try, but I would think a
Good defense attorney would scream.
a court would probably not allow it, just in the same way that just as in traffic court, the judge could never consider what an insurance company's investigations determined about who was at fault in an accident, in criminal court or in traffic court, the judges, or even in a civil case, the judge is not going to say, well, because the insurance company said you're at fault, we're going to use that like that. Usually it's just, you can't, it's a separate tribunal and this is, you're here.
But if somebody's convicted of a criminal offense, they can bring that up in a civil case. So
Yes.
does this not rise to the level of?
It probably doesn't. We don't.
Because this is not like a tribunal, you know what I mean, in the sense of
This is
one that would be recognized by.
That's right. We are
Higher.
expressly inquisitorial and not adversarial. So, you know, our fact finding is limited. Oh, sorry. Let me go back.
Nothing prevents them from trying to get it done, right?
No, of course.
That's the dance. That's the whole dance of litigation, all right?
Okay, a couple of responsibilities that the board should, individual members should be conscious of, is that, you know, we have a code of ethics, and we have a number of provisions about our allowable behavior in our operating procedures under PCOB 1. We cannot, for example, hold ex parte communications with people who have a matter before the board. So if you know someone and they've filed a complaint with us, you have to say, no, I'm sorry, I can't talk about that. And there are a few other things, you know, they ask you, oh, you have to come to meetings. Well, all right, thank you, you're coming to meetings. We will discuss conflict of interest in a short while after the break. So if you have a conflict of interest, you need to recuse yourself. If you cannot be impartial for whatever reason, it may be a personal reason, you also have to recuse yourself. And the important thing is that while the board gets access to information, it has to stay confidential until we all vote to make our public report. So if you get access to information from the internal affairs files, like you're going to get on your little tablets, that has to remain confidential until the board has deliberated and made a decision about how to deal with it. Any questions? So that's all. All of those are sort of covered in those highlighted parts of the ordinance that I sent around to you to take a look at. Any questions in particular? Okay.
Did I recall correctly that there was something in the ethics or somewhere in the code about public pronouncements pro or anti-police? I mean, we certainly need to appear neutral, publicly neutral.
Well, there is a statement about maintain the appearance of impartiality. Yeah. So, you know, there was some controversy about some board members who had it at certain points in their lives, you know, you made social media posts that were pretty openly anti-police. And so now I don't think we have that, don't have that luxury anymore. If we want to appear impartial, we want to be impartial, we want to walk. Yeah.
And when you get your standard operating procedures, you'll see your procedure number 17 is your whole code of ethics. And that covers everything, including the appearance of impropriety or lack of impartiality.
Okay. All right, let's take a few minutes to talk about you know, what's been going on with internal affairs over the last few years. When Chief Brackney was here, she started the laudable policy of publishing monthly internal affairs summaries. And they're not terribly informative. Their form has changed over time. We've had four police chiefs now, and so the amount of information that you get has changed. But it's strongly worthwhile, if you get a chance, to go onto the police website and check out, you know, the most recent summaries. I also have a spreadsheet of the information for 2019 to 2022. You can see that The, complaints have ranged from a high of 50, and maybe a slight increase over the following years. The citizen complaints, which are the ones that we can handle, have been relatively stable around 30 per year. There were, in 2019, they weren't reported, it wasn't broken down, so I don't know which of those 50 were external complaints, which were internal complaints. And the number of sustained allegations, number of complaints with sustained allegations is there also. And if you look at the table toward the bottom, what you see is a trend of the proportion of complaints that were sustained seems to be rising, which, I don't know whether that's good or bad. I think the number of allegations is dropping slightly. I think, quite frankly, that the Internal Affairs Department has gotten more focused and a little more professional over time and done a better job of determining what constitutes an allegation and making the allegation appropriate to the action. Used to be, if in 2019, if was an allegation against you, you had a 60% chance of having it dismissed as you have a 70% chance of having it dismissed as unfounded or exonerated. And that's now down closer to 50%.
Is this all complaints? Like, does the number 50, does that represent like
It's
individual people walking in with complaints? Maybe one person had 10 distinct complaints, so it could.
Each complaint is what has been characterized as a complaint in their database. So it's one complaint and it can have multiple allegations.
Thank you.
And, as I say, in 2019, they did not distinguish between which complaints came from citizens and which complaints came from inside the department. And this is what we experienced in terms of what were the most common of the internal affairs allegations. And you can see that in the early days, courtesy and demeanor was at the top, and that has gradually shifted over to performance of duties. These are not numbers I know are not particularly informative. You do have to go and look at the spreadsheets to see what that means. It does seem to me in the last couple of years that people have complained a lot about bad service at subsequent to car accidents. The force outside of policy response to resistance, this is something that comes close to excessive force, basically, what those are. The reporting of those has not been always consistent. As I said, in 2021, there was the fairly notorious case of the individual who was knocked down for being sick. But we can hope that it kind of looks like, if the trend continues, that the powers that be have made a very strong effort to make clear what the limits of force are to the police, and so their first instinct isn't to use it. One more thing I want to tell you. The Internal Affairs Department also, starting in 2021, has tabulated corrective action and punishment. And so if you could look at the internal affairs report in my spreadsheets, you could find what happens. And as you might expect, you know, for the less severe cases, we're talking about counseling. If they're counseling and documented counseling, and there were several suspensions. In 2021, there were 5 officers terminated for internal affairs reasons, and I don't know whether there may have been other officers terminated. 3 in 2022, and I become aware of 1 this year who's terminated. And so, again, sort of, you know, I don't know what that means in terms of trends. Just the numbers are just too small. So.
What is your total police force number?
Well,
it's supposed to be 120. It's 80 right now. We're down 40 officers. Yeah, it's terrible.
That's pretty.
Bad situation.
yeah, well, I think, you know.
But
I
we
think
haven't done any cases yet, right? Correct?
We have done that.
Okay.
We have attempted one and kind of didn't work.
Well, it went to mediation.
It went to a
Alternative dispute.
There
to
you
an
go.
alternative dispute
And that was
resolution.
because we either didn't have a full board or we didn't have an executive director. That's why we haven't had it.
No, that was
The
because
attorney requested it.
that was because the attorney didn't want to go through the trouble of having a hearing at which we would be fair. Sorry.
The complainant,
Yes.
attorney.
Yeah.
Oh, the complainant attorney.
The complainant was an attorney.
That is
Being
fine.
the
I'm
attorney
sorry,
for the board, I don't
realize
want
I'm
it to be
speaking in public.
imputed to me. I have no decision making.
Allow me to be a little bit fairer and to say that the complainant, who was an attorney, thought that it was going to be a full adversarial proceeding where he was going to call witnesses and cross-examine them, and that he would be given access to all, to all of the evidence in the internal affairs file. And when he found out that none of that was going to happen, he decided that he could settle for a an alternative
Dispute resolution.
analysis conducted by our executive director, which reviewed all of the information and summarized it and made recommendations.
And also in defense of the complainant, at that time, the SOPs were not well
Yeah,
expanded. I mean, there were slim sort of suggestive SOPs. They were not fully what the board could do, the board's powers, what a hearing should look like was still kind of in development by the chair and with the executive director. And so it would have not been unusual for the complainant to not know, if I make this complaint, exactly how is it going to play out before the board. So there was a little bit of uncertainty in the process that I in my view, made it kind of a natural place to take it out of.
I think I'm still a little unclear about execution of these investigations. Are we questioning witnesses? Is the executive director questioning witnesses?
All laid out in your standard operating procedures that your chair.
Okay.
I've got all these flow charts that will.
But there was one other quirk there that raised an issue, which was the person against whom the excessive force was alleged was long gone. And so the attorney took this upon himself to pursue it. And so I think we corrected that, did we not, Bill, so that the complainant has to be involved in the case. He can't just go out and get people off the street and bring actions.
Not that he did. No, that's the, this is a meeting, a public meeting here, so.
Yeah. But anyway, so
Yeah, no, so the.
complaint does have to be involved though, right?
Right now, yes, complainant or
That's my,
a witness can file a complaint
Yes.
also if they're there.
yes.
They can't file a complaint because they heard something bad happen.
Yes. Correct.
But let me, and want to clarify something. In writing the ordinance and in writing the SOPs, we went back and forth with the city attorney then, Lisa Robertson, and the now mayor, Lloyd Snug, and came to a set of what I think are very workable compromises that are well within the mainstream of sort of the best practices for oversight organizations, wherein our job is to find facts. It is not to hold an adversarial proceeding. We are the fact finders, and our hearing examiner supervises whatever questioning goes on at the hearing, and may rule out questions that he or she feels are irrelevant.
All of that is definitely spelled out in more specificity in the SOPs, which you will get. I mean, your chair was really very vigilant for, oh gosh, how many months did we go back and forth every morning, emailing, sending drafts between Bill and myself and the city attorney, and just a lot of work went into sort of giving you, answering the questions that I think are naturally occurring to you in the SOPs.
Yeah, and the rationale for that approach, I mean, is that you're taking advice from our stakeholders who were involved in writing the original ordinance. The last thing that they wanted was to have someone who filed a complaint know that they were going to go into a hearing and be cross-examined by a fancy lawyer, and that their witnesses would be cross-examined by and intimidating, making these intimidating questions. And so we have kind of tried to insulate all of the participants and the parties from direct cross-examination. But questioning is allowed.
I mean, and I, maybe I'm speaking out of school, but I can tell you that the will of the people, of the community, stayed in the SOPs that were developed. And Bill that was his sort of bottom line of, we can tinker with this, we can tinker with that, but the will of the people, because there was a very deliberative process that went into getting the community input, and Bill was very clear that should stay in the sort of the meat of the SOPs, and not sort of create an imbalance where the community didn't really have the power when it came before a board with, say, expensive attorneys representing one side, and just a poor victim or a poor person, alleged victim, coming in and trying to be heard. Sort of that imbalance is not there, and I hope when you read the SOPs, you'll feel that and you'll see that.
Trying to restore a power balance, basically. Okay, so take a 5 or 10 minute break now and come back and hear about FOIA.
Yep.
Oh,
And
exciting.
I've got so many, and don't be intimidating. I'm going to put handouts on your tables so that when you come back, don't be intimidated by the number of slides that I have, because we're going to whip through these so fast. And we're only going to talk about the things that are important to you. And the handout is really more as a reference for you to go back when a FOIA question occurs to you. You'll have this sort of guide to go back to. So I have handouts for you, but we're going to get through this lightning speed.
Are you giving us this presentation?
I will give you the presentation and some other materials. 15, it's 2:08 now. I'll be right back.
I was a little intimidated when I saw how many slides this ended up being. I was like, whoa.
You have to answer for you.
Oh,
Okay, awful. Every time I got one, I was like, oh, God.
I used to my last stint before I went to the law firm was general counsel for the Attorney General of Virginia. And I oversaw the FOIA function. So if you can imagine us being the chief FOIA officer in a office of 200 lawyers. And yeah. FOIA is, it's good.
It's an important statute.
It's an important, and it's an
Charged
important
with
priority,
going
but it
through it.
is a grueling compliance requirement. But it exists for good reasons. Sure.
Oh, God. I'm recovering from back and.
Ooh, I had one of those a couple years ago. It was the worst thing ever.
Yeah. So,
I feel for you. Are you doing like chiropractors,
but I'm
acupuncture,
yeah,
physical therapy? helped me the
anything I
most.
can get my hands on other than medication, because that stuff can. Oh,
I went to somebody when so my back was in my, it was my
Yes,
lower
we,
lumbar spine. And I
our
went to
firm
somebody that
sort of
someone
has the-
recommended
this
to me. They
unique,
called him a non-invasive
footprint
chiropractor.
of representing a
I didn't
lot of
really understand
government
that.
entities in Virginia.
So I go to
So
this
we do
guy
this kind of thing all the
and
time, so.
he wasn't
one person
expensive
will-
either.
will create it and we
But
build
he
onto it and specify.
put me
it
down
in
on a
each
table,
one.
took my
So
shoes off, put
this is
these funny
customized
shoes on
for
my
you all,
feet,
but
had me
we
lay
sort of
down on
have
the
a
table,
template
didn't
that we
touch me.
customize over and over.
And he's looking, and I have my fully clothed. And he's looking at me, he's like, yeah, I see there's some
No.
shifting of your lower
Richmond is still
lumbar to the
doesn't have
left. He
theirs
said, I'm gonna put it
stood up
on.
yet. They
said,
have not.
When I do
Charlottesville
this, he
is
said, tomorrow,
furthest ahead.
you might
of any
feel more pain than you
Virginia
do today.
localities
He
in
said, the
terms
day
of,
after that, you should be.
development. of the
So,
PCOB.
I went to the website and they said.
May I touch you for a second?
I mean, you know what I mean,
Felt
because
like
I
that.
was comparing Richmond
They-
with
And
Charlottesville.
and then he sent me home and I was like,
They
oh,
are,
this
it was
guy's
just-
quack.
I think
I
they
just
have
paid $35 for some quack.
folks,
The next
but
day,
I don't
I was
don't
in
believe
twice as
they're
much pain.
functioning yet.
The day after that.
Right. And I know Charlottesville was the first to start
To
putting it together.
Come on, I was like in my head going, no way. So I go back to him a second time. Well, I'm gonna try one more time. Go back to the same thing, takes shoes off.
Yes,
Puts these funny
yes,
shoes on, he
yeah.
looks at me and goes,
Sure.
well, I'm
Well,
glad to
either.
say that it hasn't shifted to the
Yeah,
left, but it
that's
seems to have
right. We can
shifted
make
up
it-
without
we
touching.
Wow.
It seems to have shifted up.
Or
I'm gonna put it back in
guinea
place.
pig.
Same thing, touches me like that. Says, okay, you can go home. You'll probably feel worse
This might
tomorrow.
be an obscure
Felt
question.
worse the next day.
Jesus,
And I was like, okay, this is so woo-woo for me. I don't understand what's going on, but do you know he fixed
It's
it?
probably response to the Crown's
Fixed it.
arbitrary.
I'll be happy to give you his name.
he's.
So, and he's not that expensive. He charged me like $35 each time I saw him.
Not with the Crown.
I'll give you his name. He was amazing. And, but when you're with him, you do kind of like, I don't get it. Because I had gone to a regular
Protect citizens
chiropractor.
against that, because the Crown could do anything they want.
And
They could
it-
keep off the streets, they
right,
had you
right,
without
right,
cause.
right.
And he was a good
So
chiropractor. It just
when
wasn't.
it didn't fast
what I
forward,
needed.
it says, no,
This
it's
young
reasonable
guy
to
just
sign up the
opened
Crown
a
effectively.
place
I'm
off the joint.
objectively reasonableness of.
Yeah.
I went to my,
So didn't it
the
get twisted
other
somewhere
one I
along the
felt,
road in 200, 400 years
because
of
I
history? or however
found
many?
out that I have
Well, it's,
neuropathy.
I guess it's.
And I'm no lawyer, I'm
It's
just
kind of
like-
that original intent.
Finally,
And that's what all the
versus
Scalia
then-
crowd
versus
wants to
to
talk
find
yeah,
about.
out
versus
why
how
you
it's
found.
Been interpreted.
interpreted over the years and how
went to
society actually uses
The
it.
guy,
Because it seemed to me this
my
court
other
then
one
might,
that I went to out of
if they really
desperation.
are
Now, before,
what
he
they say
was,
they are,
you know,
would argue that
just, you
the
know,
intention was reasonableness from the point of view of the
all of
citizen.
this,
arbitrary
nothing
and
to move
passed by
me
the Crown.
except
And I
pressure.
think the way
on
they
the
get it, they sort of
back,
reconcile
which-
that is.
Almost like
over the
massage?
years,
Yeah,
they say,
which
well,
was,
even
yeah,
in Grand versus County,
you
they
know,
say,
so I go
well,
in limping
very difficult
and
to get in the
hanging
mind
over,
of
and I
each
leave
person,
like that.
each citizen and each
never
person
happened
every time we have this, so
with
we have
the
to have
chiropractor
a
I
way
had in Chesterfield.
a test,
So
a
I
standard
found a guy
by
to
which,
join. I
through
went
which we
in,
review all of
could
these
hardly
things. So,
I
get
would
it.
argue that a trier of the fact,
He
especially a
put me
jury,
on the
could say
had this
what they
table
consider
go down.
reasonable from the
The
perspective of the
shifts,
citizen.
right?
You know, they could say,
And-
okay,
I've done that.
And
you know,
I
Jeff
got up
was,
Should you
and
reasonably
go
have
down.
expected this?
and I was
Yes.
like,
Well, and see, but it's,
You know,
That's the thing about chiropractors.
it is
They
a
either
reason, a reasonable, would a
or they
person
don't.
believe they have
You know,
a reasonable expectation of
And
privacy.
Privacy, for example.
And so then it does.
And a
it does
jury would
decide.
say,
You're right, excuse me.
they would
Yeah, so it
decide
doesn't-
from my perspective,
But they,
what's
but it's
reasonable.
still objectively reasonable. Would a reasonable person,
Right.
citizen have believed they had a right
But-
to
but
an
the onus
expectation of
is-
See, I
privacy?
don't think the decision was wrong in the Supreme Court in terms of their test. I think the application of what reasonableness means is where they go.
But
Because I
did you-
think,
did you hear
And
my
that's what,
argument,
that's what I,
Susan?
that's what I,
understand that an upper court never is really supposed to review facts.
But what I'm saying.
They're
but they
supposed to
sometimes
deter-
do,
they
but
do.
they didn't hear. They
But they
didn't hear
should
at all.
determine what the law, what the standard test should be.
Like,
And if this
it should-
court, my
it should
point is,
say-
if this court is all about original intent, the original intent of the Fourth Amendment was to protect the citizen from the crown. Because they took it from English law, that the crown shouldn't have the option arbitrarily to sweep you off the street and behead you. So the reasonableness in terms of the trial of the fact should be what's reasonable for my expectation as a private citizen. But it's shifted to the crown in the form of the police.
Well, it
Well-
did, but there's also,
I was gonna say, speaking to the guy who argued it. And I read the, I think it was the appeals court decision. There was a line in there in the decision that said, even the plaintiff's doctor said that it was appropriate to handcuff him at that time. And the lawyer said, what? I never heard that.
That was in the facts?
It was in the decision. It was in the, I believe it was the.
but see, that's one of the problems though. In this board, we cannot punish a police officer for doing what the law tells him he can do.
Right.
Right.
That's the
No,
problem
yeah,
that we run
that's,
into.
and that is
Because the
absolutely.
reasonableness standard is over there. It's not with a trial of the fact saying I've been mistreated, my rights have been violated.
Yeah, and see,
What
and
I
that is
hope we
why I
can
say, if Marshall knew how Graham versus Connor would be used over the
Applied,
years,
he'd be
he probably,
appalled. I don't know if he would have changed the standard though.
not the standard, but he might have brought a, maybe, well, I mean, he
More of
was,
a
he was in the minority.
A
and
little
it
bit more of a
would have been-
subjective.
Yeah, I think there would have been more of a, because the only part of Graham versus Connor that I don't like is when they say even an officer with
Yeah,
bad intent,
doesn't necessarily do.
if what he
Isn't
did was
necessarily
subjectively
excessive.
reasonable,
Doesn't matter.
it doesn't matter that he went in with bad intent. And that part to me
Sits
is
badly with you.
that it sits badly because it almost creates an overlay of the.
My intent doesn't matter.
The
Well, look at-
objectively reasonable standard.
What
because-
about Bull Connor? I mean, you could argue, objectively reasonable to get a fire hose on protesters, right? Hello, doesn't his views on race go to?
And that came before Graham versus Connor,
I
but
know.
Graham versus Connor would say that the fact that Bull Connor was a raging racist
Racist, doesn't
and his
matter.
actions against, African Americans, it doesn't matter what he thought, it just matters whether or not he believed that there was imminent harm
to the
or
community or-
or there was threat, or if he could just articulate the Graham versus Connor test, the standards in the test,
I don't like it.
then it wouldn't matter.
So
And see,
shall
and that,
we,
so that part is,
shall we
But we have to be careful in this regard that we don't start to apply
what we think.
what we
own-
think
no.
the law should be to what the law is.
No, I get that. It's just sticks in my craw.
that's-
But I do think we can look at a set of facts and say, okay, that's not really reasonable, even from a police officer's
Sure.
standpoint.
Well, see, and that's where I think that the power of the board is to affect the policy to sort of change what is the reasonable sort of local, what is subjectively reasonable for a Charlottesville
Charlottesville.
officer to do, because this is what policy tells him is a reasonable officer standard. This
Right.
is what his training says is,
And the
that is the-
reasonableness standards should take the flavor of the community and the, the political not the political environment, but
the community standard.
community
values.
standards, community values, community standards should be part of that.
Yeah.
test. And I think that, from what I gather so far, which pleases me, is that the chief of police seems to say he has an understanding of that.
Yeah.
It remains to be seen whether that. True or not?
I haven't met your new chief, but.
I met him the other day at over at YMCA and I
He's
really liked,
terrific.
really liked him. I thought he was very reasonable and he was not above saying, I expect my officers to be courteous. I expect them to be polite. I expect them to follow the law. He was very.
Well, and it comes from the top.
And
It
it
really
should be.
does. It comes from, he models what he wants to see in his officers. And if officers see
Yep.
him modeling,
Yeah.
being in the community, being a voice.
Exactly. And have you gone on any of his walks?
I
I
live in
want to,
Richmond, but
I
I,
want to go. I just haven't gone yet.
I've seen them on Facebook. That's how I know about them.
Yeah, it's great.
And it's.
And the community is very, yeah, the community is loving it.
We're doing candles.
Yeah.
But yeah,
Yeah.
it's,
I'm excited about it.
yeah, I was really, I was driving back from Pennsylvania when you all had the Chiefs Forum with the three,
Yeah, 3 candidates.
and I was listening and I was like,
Says all the right words.
I'm so sorry. It
You know,
was
his
very-
advisory board, and first of all, his department in Warrington is fully staffed. A third women, third African-American, third white officers. In Warrington. And his advisory committee, all the black clergy, BLM a member on his advisory. I mean, NAACP, business leaders, attorneys, I mean, it was the whole community. He's gonna do that here.
See, and that was the thing
What
that,
message is that sending?
that
It's
was
so
impressive
powerful.
about him, you know, and all of your candidates, you had 3 good candidates, but the one thing that was impressive to me, listening to it was, you didn't have to wait and just believe what he told you he would do. He had a track record for doing it elsewhere.
And the mayor told me that when he called that mayor to check, he said, oh, boy, we are heartbroken. When our loss is your gain, you're gonna love this guy. And he wasn't just being polite. I mean, he said, he is
And she's
found me.
actually gonna talk about conflict of
That's-
interest.
Okay. Well, I hope
I mean,
y'all can stabilize and hold on to him for long enough to make that impact, you know?
Okay,
Oh,
now
I
the,
should have been working on getting this uploaded, huh? Or for me to,
Well, you guys were having a really good conversation.
I'll stop sharing.
and do I have the power to share? I don't see it. No.
Move the cursor down toward the
Okay,
bottom.
join it. I just joined as a panelist, so.
Oh,
All right, now let's see, where can I share?
Little green arrow at the bottom.
Oh, there it is.
All right.
Here we are, Virginia Freedom of Information Act and the Virginia Conflict of Interest Act. So we're gonna really just high level go through both of these. The Virginia Freedom of Information Act is relates to how the public entities, public bodies conduct meetings and how they handle documents. It comes, the Virginia Freedom of Information Act comes from, let's see if I can figure out, okay. It's a statute, Virginia statute, and it says, basically stands for the proposition that our government belongs to the people it serves. By extension, information retained by governmental entities likewise belongs to the people subject to legislatively mandated exceptions, one of which is explored here. This is the foundation upon which the Virginia Freedom of Information Act rests. So we as taxpayers fund the government. What the government does is on behalf of the taxpayers. So what the government creates belongs to the taxpayers. That is information, that is documents, and that is why the Freedom of Information Act exists. So for the purpose of the FOIA, and I won't keep saying Freedom of Information Act, FOIA for short. It provides the public access to meetings of public bodies, of which the PCOB is one, access to public records unless those public records or those meetings of public bodies are specifically exempt under the statute. What is a meeting? We won't go through all of this, but meetings means the meetings can include work sessions when sitting physically or through electronic communications. We all know through the pandemic that it used to be very uncommon for there to be such a thing as an electronic meeting. You might have had people who could call in, participants who could call in remotely, but the body itself would have to sit physically. The pandemic sort of made that a big change in Virginia, and there were all sort of continuity of government ordinances and laws that allowed public bodies to meet electronically in order to maintain public health. So as a body or entity, or as an informal assemblage of as many as 3 members, and Bill loves this because we've had this issue, and we'll talk about it when we get to the specific of as many of a meeting is when you have 3 members of a public body or a quorum of that public body getting together to discuss public business. And a quorum is if the body is less than, if it is less than 3 people, that creates a quorum, meaning more than half, then that is a meeting. What is not a meeting? The gathering of employees of a public body, nor the gathering or attendance of 2 or more members of a public body at any place if you're not getting together to discuss public business, right? So all of us could go and say, hey, well, not us, because I'm not a member of this public body, but you all as a public body could say, you know what, on Wednesday, let's get together down in the mall and let's have lunch. If your intention is not to discuss the business of the PCOB, that is not a meeting, that is not implicated by FOIA. Social events, not a meeting, social events, sporting events, all of these things, and if you're not discussing public business. Forums and debates really doesn't really apply to you all because you are not elected officials, so we'll just fly through that. We're gonna go through meeting requirements. Meetings must be open to the public unless the meeting is subject to an exception that allows for a closed meeting. All meetings must be conducted in person where members are physically assembled, except as provided by these 2 statutes. And these 2 statutes speak to the public emergency statutes that allow public bodies to meet electronically. I will tell you that electronic meetings is an issue that is very much newly in flux based on a March 23rd, 2023 case from the Virginia Supreme Court, Berry versus Fairfax County. So we as lawyers are still trying to assess and trying to help local government entities figure out what that decision means. So we're not going to spend a whole lot of time talking about whether you have the ability to continue to meet electronically, because we're going to be talking about that more extensively in Charlottesville and throughout Virginia, just to assess the impact of the Virginia Supreme Court's recent case. Meeting requirements. In order for a public body to meet to discuss public business, there must be notice to the public. The public must know that the public body is getting together, and there are notice requirements. Notice must be provided on a government website if you have one. PCOB has one, the city of Charlottesville has one, or in a prominent public location at which notices are regularly posted. And we all know prior to the internet being so prominent, you'd walk in a public building and you just see notices, public meeting, public meeting, public meeting. If the city or public body still has such a board, public notice board, meetings have to be posted there in addition to the websites or at the clerk or the public, the office of the clerk for a public body can post these notices as well. So the public body cannot get together and lawfully meet unless the public is on notice that the public body is going to be Notice must be provided to anyone who has requested it in writing, and the notice must be given at least 3 working days in advance of the body meeting. The agenda and materials must be made available at the same time to the public as it is provided to the members. So in this case, if PCOB is not going to use an agenda, you're not required to create an agenda in order to give to the public. But if you create an agenda and you provide it to one another, the public has to be provided a copy of that agenda at the same time as the members would be provided.
Yeah, just for your information, the ideal for us is to have an agenda for our monthly meetings 1 week before that, posted on the city website. Sometimes that doesn't happen till Monday. But that's where the agendas will be. That's where whatever material will be is as a matter of custom.
And Bill knows the ropes and Jeffrey know the ropes because they've been on the board for a while. But if, say, Bill and Jeffrey are not sort of involved for whatever reason or out of town, and one of you has to take over getting the meeting noticed up and all of that, that's why I gave you all handouts. You should refer to this in terms of, well, what kind of notice are we creating an agenda? Who needs to get the agenda? What you would never want to do is create an agenda 2 weeks before and you all circulate it, you're talking about it and you're changing it, and you haven't publicly posted the agenda. If you all have it and you all are working with it and using it to prepare for your meeting, the public has a right to have access to that as well. Emergency meetings, for special emergency or continued meetings, notice must be reasonable under the circumstances. And there's that reasonable word that makes lawyers stay fully employed, because reasonableness is always going to be something that it creates sort of debate and difference of opinions, but notice must be reasonable under the circumstances to the public. So if you all had very specific to the issues you all will deal with, if there were, say, an extreme police event, public safety event where there was maybe an excessive force, or there was like the Charlottesville riots that happened here, and that happened on a Saturday, and you said, well, we need to be talking about this right away, and you needed to call an emergency meeting on Monday. Nothing prevents you from calling that meeting, even though you can't give 3 days notice. You just have to, the notice still has to be provided, but it has to be reasonable under the circumstances, meaning as soon as you know that you want to get together and as soon as you all settle on a time, that time needs to be provided to the public. So as soon as you all give it to each other, and that's a contemporaneously, as soon as you all settle and give notice to each other, the public needs to be notified of an emergency meeting. Votes of a public body must be taken in an open public meeting. No votes can be taken except at a public meeting. No votes may be taken in a closed meeting. There are no exceptions. The vote of a public body is the action of the public body. You all don't act except through your votes to do something. So that can never be done in a closed session. That can't be done sort of in your informal, well, we're going to send an email poll around to each other about this or that, and Bill will keep track of, well, 3 people said yes, 4 people said no. If that is a vote by the body, that has to take place in a public forum. It cannot be a private vote. This particular issue has more FOIA litigation than anything. So be aware of that.
Yeah, so every finding is a recommendation or a finding of that someone has in fact violated the guidance. It's all public, so your vote will be taken in public and recorded.
Meeting requirements related to recordings and minutes. Any member of the public, if this is a public meeting, could come in and say, I want to start recording this meeting, and you absolutely must honor their request to do so. If they want to take photographs or film, because it is a public meeting, they have the absolute right to do so. Minutes must be taken at all open meetings. Minutes must be in writing. And here's the exception. Minutes are not required for committees or subcommittees appointed by the governing bodies unless such commission, committee, subcommittee meeting includes a majority of the governing body. So for instance, you as a PCOB are the governing body in this situation. If you create a subcommittee to say investigate or to redevelop a policy, to rewrite a policy that you want to propose to the police department. And if you just take two people are in this subcommittee, those two people are not a majority of the body. So when they meet to create that policy or to discuss the minutes, you don't need to create minutes for that subcommittee because that is not a majority of this body meeting. Does that make sense? And here are just some specifics about minutes: date, time, location of the meeting. It must say who's present. It must summarize the discussion. And when they say summarize the discussion, you can't just say at our meeting, we discussed excessive force, right? If you discussed excessive force as it relates to 4 citizens, and you decided that you wanted to convene a meeting with the chief of police to discuss the excessive force policy, it is not enough to say we discussed excessive force. There must be more specificity because remember, you are doing the work of the public. The public has a right to be able to go back later and read and see what their public body was doing. All votes taken have to be recorded in the minutes. The ayes and the nays must be recorded. If there are motions and certifications for closed meetings, that must be a part of the minutes. And that's one of the things, Bill, that probably, I don't know, can't remember if we've done closed.
We haven't done.
Usually when the board needs to go into a closed session, maybe you're going to receive the legal advice of your counsel. Like if the board is in the middle of a review hearing and you all say, well, I think we need to talk to our attorney so that our attorney can advise us whether, what is this standard that we should apply to this, or whatever you want to talk to your legal counsel about. That is one of the exceptions that allows you to go into closed session, because that legal advice from an attorney is one of the exceptions under FOIA that allows a public body to remove themselves from the public's eyes and ears and discuss and to receive legal advice. So in those cases, what the public body has to do is make a motion to go into closed session. And they have to specifically state why they're going into closed session, what exception under FOIA allows them to go into closed session. And they have to agree to only discuss the business that gives them an exception. Like you can't go into a closed session to get legal advice and then start talking about, well, how are we going to vote on that policy? You can only discuss the business that allows you to go into closed session. And then when you come out of that closed session, you have to certify that only the business of the closed session that was authorized by the closed session was discussed in the closed session. Whenever you need to do that, your counsel will give you written motions that you can read and put into your minutes to say, on X date, we're going into closed session. This is the FOIA exception that allows us to go into closed session. We're going to discuss this. And then when you come out of that meeting, we give you language for certification that you read into the record to say, we certify that we only discussed these things, just so it's clear. And those become a part of your minutes. We're going to skip over all these electronic meetings portion because, again, that's all kind of in flux right now. But remote participation, even when the body is present, let's say, 6 of you are present or 5 of you are present, individual members do have a right to remote participation, but only under certain exceptions that are granted under FOIA. Like you cannot have a member of this public body who only participates remotely. Because one of the things about the open meetings law is they want citizens to be able to have an opportunity to interact with their public bodies. to interact means to do so, I would assume, more than just electronically, right? They want you to be present. They want the citizens to be present, to have sort of that town hall kind of opportunity. So individual members cannot say, well, I'm always going to just show up electronically. These are the exceptions. This Virginia Code section allows remote participation by individual members if the public body has adopted a policy allowing remote participation. And the remote participation can be allowed based on disability or medical condition that prevents physical attendance, a medical condition of a family member, the member's principal residence is more than 60 miles from the meeting location, or a personal matter. And if there's a personal matter, the member is required to identify with specificity to the board in the open public session what the personal matter is. Obviously, they don't have to give like too much detail that would violate their privacy, but they would have to say, I had a death in the family, or something sort of very broad. And even if that person has a valid exception, they can only miss 2 meetings per year, 2 meetings or 25% of the meetings per year, whichever is greater. So that is something that would have to be sort of kept track of probably by the chair or someone to say, okay, you've already missed 20% of our meetings, you're bumping up against that remote participation limit. Closed meeting, that's where I said that we could write a motion for you if you're going into closed session. And there are exceptions, I call them exemptions, that allow you to go into closed session, and they are specific. You can't go into closed session just for anything. It has to be one of the reasons that FOIA specifically allows you to go into closed session for. These are some of the closed meeting permissible purposes: to discuss personnel matters. For instance, if you all, when you get to the point where you're hiring an executive director and you want to talk about the contract and the decision that you're going to hire this person or that person, that may be a reason to go into closed session, because that is a personnel matter. And then this just kind of details a lot of the reasons why you could. And that's the certification that I talked about, which you would have to put on the record after you come out of closed session to say that we only discuss business, allowable business. In your closed session, you are permitted to have non-members of your board go into closed session with you if you believe that they're necessary to promote or to discuss or to go through the business that you need to discuss in closed session. That can be a lawyer, that can be a consultant, anybody that you think would help inform whatever you're going into closed session for can come into that meeting. And the materials that you prepare for in closed session, for instance, if you're having that conversation regarding the executive director hiring decision, you might have that contract that the executive director that you need to review with the rest of the board. You may have salary information. All of those documents that are prepared specifically for a closed session are exempt, meaning protected under FOIA, and can be kept private. Public records, so we switch. So I said FOIA deals with meetings and it deals with records. Public records, what are they? All writings and recordings that consist of letters, words, blah, 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 all of those things, prepared or owned by or in the possession of a public body or its officers, employees, or agents in the transaction of public business. Here's the thing that people get caught up on, and when I was at the Attorney General's office, this used to happen all the time. We've had documents on documents on documents, and a reporter would call, fully aware of FOIA. Reporters know FOIA better than anything. They'd call and they'd say, well, we got your documents and we'd like you to answer this question, this question, this question about this investigation. FOIA does not require a public body to create documents, answer questions, or do any of the things that other than share documents that are not exempt with the public, right? So you're not required to create a report, like, well, we'd like you to analyze these numbers that you told us and tell us why such and such percentage of the police officers were fired. Well, if say a FOIA request came to the police department asking, why did you lose 2 officers due to misconduct in this year? And why did you lose? Please answer the question. Tell us why you lost these, you didn't retain these officers. The police department has no obligation to answer questions, to create a report, to create any document in order to comply with FOIA. FOIA deals with sharing of existing documents that are held by the public body or its officers. And so even experienced FOIA folks get hung up on that all the time. Susan, I saw you were nodding like, do I have to answer this reporter's question? Not under FOIA. Public records are open to the public and must be produced upon a proper request unless an exception, and I don't like exception, it's exemption applies. These are the people who are entitled to public records in Virginia, citizens of the Commonwealth. So if you got a FOIA request from someone from Pennsylvania saying, hey, we just want to see how your PCOB runs because we're thinking about putting together another one. You may want to share your documents, but pursuant to FOIA, you don't have to, because if they're not a citizen of the Commonwealth, they have no right to the documents of the Commonwealth. Other parties that are entitled to public records are newspapers and magazines with circulation in the Commonwealth. Because most media now is sort of online and you can access it and it's circulated everywhere. There's almost no way to get around. It used to be, if it were the New York Times and they requested something from Virginia before everything was media was online, you might be able to tell the New York Times, well, you don't have a circulation in the Commonwealth of Virginia, so we don't have to answer. But now pretty much any newspaper or media inquiry is going to fit the bill here. So let's see. There are more than 135 exemptions under FOIA that permit a public entity or body to withhold documents. Most exemptions give the public entity or body the ability to either deny producing the records, meaning we're not giving them to you because there is an exemption that says we don't have to give them to you, disclose the records because they have the discretion to say, okay, even though we could withhold these records, we're going to share them because we think we want to be transparent. The public body can decide that. Unless, again, the disclosure of those records is prohibited under some other statute or rule. In this case, for PCOB, the city manager has the power to decide what is to be disclosed or held exempt. And we're gonna dig into that a little more.
Can you just redact certain things too?
Redaction is, yes, that's sort of part of the disclose. You can disclose and redact. Let's see. So looking at your authorizing statute ordinance 2-452, it specifically talks about access to department information. And this again is the PCOB ordinance. It says the board is authorized to receive and shall be provided full access to all department records that are determined by the board to be necessary and requested to carry out your duties. These records shall be provided to the board, subject to board procedures adopted with council approval for the protection of confidential information as defined in such procedures. Now, what this means is because City Council has said you have an important function, we want you to be able to receive what are otherwise confidential documents of the police department, or maybe not even confidential documents, but documents that belong to the police department. We're going to compel the department to share them with you. Because they are sharing them with you does not make you the custodian of those records, does not mean you now own those records. They still belong to the police department, and the police department is the entity through the city manager that makes the decision about whether they will be shared or held confidential through FOIA. So also your another or part of 2-453E specifically says related to confidentiality. Each member shall maintain the confidentiality of all confidential or privileged information, including but not limited to materials from the police internal investigative files, disciplinary actions, memos, and reports, statements of any police officer or civilian employee who was required by the department to give a statement. So that is part of sort of the process. If the city manager has to become involved to compel a statement by an employee, that statement, because it was compelled, is considered confidential. Criminal investigative files or any other information that the board, you itself deem to be confidential. So the records are to remain department records. That's in your ordinance. The chief of police, as the custodian, shall be responsible for decisions as to whether copies of such records may be publicly disclosed, subject to the direction and control of the city manager. Oops. So the key takeaway from this one is access to records to conduct your business does not make you the custodian of them. So you may get an internal affairs file that you can review or copies of it. That does not mean you are now the custodian that gets to decide whether you will, with your own discretion, share it subject to FOIA.
What if we do an independent investigation and generate documents?
The documents that if you generate them, for instance, if you go review the police files.
Well, I'm just saying, we don't have, no, we're not reviewing the police files. We get a complaint. And we do an independent investigation from the ground up. We do our own.
And those documents belong to this body. Okay. If the police department says, okay, we will share Officer Jones's personnel record with you to support that investigation, that personnel record still belongs to the police department and you don't have the ability to disclose it. Your investigation, you can disclose all aspects of it, but if you summarize that personnel report in there, that would be one of those sort of inflection points in conflict where I would imagine the police department would say, hey, you only know this because we shared our document with you. So if you are going to publicly share that document, we are going to request that you redact that personnel information out of it.
Final decision maker on that would be the city manager.
Right, and if so, and that this is one of the very good things about this ordinance is if PCOB says, we now own this information, and the chief of police says, no, we own that information because we gave it to you, and PCOB says, well, we own it, we want to share it with the public. That dispute goes to the city manager who oversees both entities, and the city manager decides that dispute. And that's just by virtue of the ordinance.
And the subtle point here also is that if we generate documents, we generate an investigative report and we receive a FOIA request and we claim a law enforcement exemption.
You can.
Okay.
You can.
Yeah,
Because, but particularly if it's, I would imagine it's going to be heavily populated with law enforcement information. So law enforcement investigative files are one of the exemptions under FOIA that allows you to not disclose it publicly.
Yeah, I think it's, okay, never mind.
So, and here is an important detail just for all of the members. In the operating procedures, which were ratified by City Council, it is grounds for removal for a member if you violate any of the confidentiality provisions that we've just discussed, or as they are laid out in your SOPs or in the ordinance. So that's really kind of an important thing to remember. It's not, you can't decide, well, shoot, this is really a radioactive report we've got here and the rest of the board doesn't want this out in the public, or the board's still trying to figure it out. But I think, I think this needs to get out here now. If you take that and you go ahead and you try to, you're gone. That's grounds for removal.
And but only if the city council votes that you're gone. The city council has the sole right to remove anybody from the board. I can't remove it. We can't remove anybody. It's a city council.
So the way that would play out, not that any of you would ever do such a thing, but that would, and it's laid out in your SOPs related to your code of ethics. The way that would play out no, your general operating procedures is, again, the board member or chair becomes aware that a member has violated the code of ethics or the confidentiality. They take that information to a member, to the city manager or city council. City council has the power to remove. Again, as Bill said, no one else has the power to remove you except the entity that appointed you.
It used to be in the old ordinance that the city council could remove you, period. Now the city council can remove you for cause only, which are spelled out in the operating procedures, so.
So, and here you see categories of exemptions, which was your question, Bill. Public, these are the categories that are exempt, meaning that can be with, that are not required to be disclosed, subject to a FOIA request. Public safety records are in, or a part of that, and law enforcement records. Common exclusions, many. When is a FOIA request made? A FOIA request is made if any member of the people or the entities that I said could request it, if they say, you have information, a document, and I want it. It does not have to be specific. They do not have to say the magic word FOIA in order for it to be considered a FOIA request. It does not have to be in writing. Again, it does not have to be in writing. It does not have to reference FOIA. A requester has a right to either inspect the document or to request a copy of the document at their election. You can't say, well, we won't give you a copy, but you can come in and see it. No, they get to decide whether they want to copy it. And if they want to copy it, there are costs that can be assessed to the requester.
Pam, is it true that often agencies will just charge exorbitant fees to try to, I mean, I've heard of people-
I've heard stories to that.
Yeah.
Well, I have heard stories of that. I was on FOIA council with the legislature when I was in the Attorney General's office, and that was one of the considerations on FOIA, by the FOIA council, about whether the FOIA statute would be amended to limit a public body's ability to charge in excess of certain fees,
caps.
to put caps on it. And I believe there, in the final bills that came out, I believe they did put some restrictions on it, but not full restrictions on the ability. I'm not going to go through how you respond to a FOIA request in detail because you all don't do that. Your body is, and I'll scroll down. Here we go. FOIA complaint. The city's FOIA officer serves as the FOIA officer for the PCOB. So what you need to know about responses is if someone requests a document, you need to very, very quickly talk to the city's FOIA officer about that request. The timelines start ticking from the minute the request has been made.
Who is that person? Do we know?
It's on the city's
It's
website.
usually the city attorney, but I mean, Lisa was doing it when she was here. I'm not sure who's doing it now.
Yeah, and I, but it's on the website and I don't know who that is, but, so I'm just gonna go back to say, 5 days, most of the FOIA responses, there is a requirement that something starts happening within 5 days. So if someone comes to you on Friday and it's 5 business days, and they come to you on Friday and you're like, oh, well, I'm going on vacation. I'll tell the city attorney or FOIA officer on Thursday when I get back. By that point, it may be too late to do that, and you may be out of compliance. So do not sit on a FOIA request. There you go. 5 work days to respond. You can get a 7-day work extension. And I've actually litigated one of these non-compliance cases where you end up going to the court if the requester says they haven't complied with the timelines or they haven't given me what I requested, and I know that they have. And it can be an expensive bit of litigation for the city. Cost of production, none of that really matters. I mean, it should matter to you. It costs the city to produce documents subject to FOIA. Reasonable charges are allowed to be assessed by the city. Violations of the act. Again, there are almost never do these happen unless they're egregious, willful violations of FOIA. If there is a violation of FOIA, there are certain things a public body can do to sort of insulate themselves from harsh penalties. They can say they relied on the opinion of an attorney general. And there are a whole number of attorney general opinions about what documents must be produced, what exemptions apply, which exemptions don't. So if you say, oh, we pulled this attorney general report and it said that this document was exempt and I relied on that, and the court says, no, we disagree. You should have given that document. Well, the fact that you relied on a specific attorney general opinion can somewhat insulate the penalties for violations. Court cases, FOIA advisory council opinions, and even if you can prove that you went to your local government attorney, in this case me, or city attorney, that can provide some insulation. That is FOIA. Any questions? Because now we're going to fly even faster through conflict of interest because most of this does not apply to you. But any questions about FOIA or public meetings? Conflict of interest. This presentation is general in nature. It is not a substitution for reading the act or receiving advice from your Commonwealth's attorney or COIA counsel. So the Conflict of Interest Act has been around for a while, but it was heavily beefed up after the Bob McDonnell governor's scandal that happened, what was that, maybe 10, 15 years ago?
20 years ago.
When it was believed that he was, well, I guess it went to court and he was convicted. So when he was taking, maybe not bribes, but favors
I
from,
seem to remember a fancy wristwatch. or
yes, a
something like
fancy
that.
wristwatch, a
car.
drive in an expensive car, vacations and other things that
jets.
could have affected official decisions. So they really beefed up the Conflict of Interest Act after the Bob McDonnell scandal came along. So the General Assembly sought to ensure that all levels of government remain untainted by corruption by prohibiting involvement of legislative members in certain activities, contracts, or votes where their judgment would be clouded by personal interests. And they wanted to establish a common body of law on the subject of conflicts, and they wanted to promote transparency through disclosure of certain types of interest by elected and some appointed officials annually or before certain votes. Let me just highlight this part and say to you, thank your lucky stars. You do not have to do disclosures, which have to be done every year, where you would provide financial information, gifts, and any number of things. When I was on the bench, we had to do that every February, and it was a grind, just going through that. But prohibited conduct, this does apply to you. No officer, and you are under the statute, officers or employee may solicit, offer, or accept consideration for performing services that are within the scope of your official duties. You can't say, you've got this case coming before you guys, and I'd love to just take you all, the board, to lunch and let's talk about, that case, or, it'd be really great if, the board would decide this way, and, we might be able to, give you some encouragement to decide the right way. That can't happen. You can't, you can't receive anything for obtaining employment, appointment, or promotion of any person within a government or advisory agency, meaning you couldn't say your new executive director's cousin says, if you hire my cousin, we can make it worth your while, right? That kind of thing is a conflict of interest. And you can't use your public position to obtain some kind of contract that benefits you personally, that the government entity pays for. So PCOB board members are officers under the Act. Officer means any person appointed or elected to any governmental or advisory agency, including local school boards, whether or not he receives compensation or other emolument of office. Prohibited conduct, no officer or employee may use for his for his own economic benefit or that of another party confidential information that he has learned because of his public position, if it's not also available to the public. Again, you can't, be influenced by anything to affect your position. No gifts. No officer or employee may accept gifts from people affected by the performance of your duty. You may not accept a gift, accept so many gifts as to give the appearance of the use of your public office for private gain, meaning, now that you're a member of PCOB, suddenly, certain police unions are very interested in, giving you tickets to see the commanders, right? And so if they're in, even if, or taking you to lunch, or just dropping off baskets of chocolate, right? If a collective, if you're receiving so many gifts or gifts in such a series or that relate to each other from one entity, such that it gives the appearance that they're trying to affect your decisions, you should cut that off. We used to, when I was in the court system, every Christmas, the attorneys would give our clerks, bring baskets of cookies and baskets of, and we as the judges, they'd send it to the chambers, to the judges, and we take it and we say, nope, give it to the clerks. We can't touch them. And, it was very tempting to always to be involved in that, but we had to remove ourselves from the appearance that we were, being bought with sweets. And you can't use your public position to retaliate against any person for expressing views on matters of public concern or exercising their rights. Gifts valued in excess of $100 individually or in the aggregate are prohibited from lobbyists. You all are not going to be lobbied in terms of these specific, there's a legal definition for lobbyists, which would not apply to your work. Exceptions to gifts, you can take a look at that. You can certainly still receive gifts from personal friends and all of those things, but as long as it is not a personal friend that creates a conflict for you in your decision-making on the board. These are exclusions, things that are not considered gifts. Personal interest, generally, this does not apply to you. Personal interest talks about financial transactions, which you all really aren't going to have financial transactions as a part of your work. So ownerships in business, income that you receive, that's kind of what this speaks to. And that really talks about transactions. So conflict, what do? You have if you have a conflict and there's no exception, you must disclose that you have a conflict, meaning to your board, to the public. If you are, say, coming up for a case and the person who is alleging that there's been police misconduct is a cousin or a coworker or someone that you have a close relationship with, or maybe someone 5 years ago that you knew that you really don't have much relationship to anymore, the first and most important thing is to disclose. Disclose to your bot, to the rest of the board. And if you are sitting in a public hearing, disclose in the public hearing. You don't have to give great specifics, but you could say, I used to work with this person 5 years ago. We went to lunch many times. I have some familiarity with them, but I know nothing about the facts that they're bringing before the board. But if there is no exception, and if you believe you cannot be impartial, then the obligation is that you cannot discuss the transaction, the case, you cannot participate in the closed meetings, and you cannot vote on the transaction. You can still sit as a member of the public body in the public setting. You just can't vote, you can't participate in the closed meetings, and you can't discuss the transaction. So again, there at the bottom, the declaration must be made either in full in the minutes or in full in writing with the clerk if you have a body that has a clerk, and referenced in the minutes and must be repeated at each meeting in which that business is discussed. So that is again, a requirement in your minutes that we talked about before. If there is a conflict of interest that is disclosed, that is an essential thing that would have to go in your minutes.
And I have a question about that. So with my password, with HIPAA, I can't share like who I had as my clients. And so what if there is someone who's filing a complaint that I used to provide services to? Would that information be shared privately, or will I still have to share that? in
Well, you
public?
couldn't share it privately unless it would be an exception under the closed meeting and I would have to I could look at the closed meeting to see if there is such an exception. But what could happen is you could say, I cannot disclose the background, but I do have a conflict related to this person. And you don't have to get in all the specific details if the conflict would require that you disclose confidential information.
Yeah, our operating procedures are a little broader than COIA, and it basically lays emphasis on being impartial. And so if you feel that you cannot be impartial for whatever reason, you can consult and then may decide to recuse yourself. Because I have, personal knowledge of this, and again, that's
Right. And again, if in that scenario, that this person through their medical background, you don't have to disclose that. I have knowledge that could present a conflict of interest for me, so I will recuse myself. So this is important. So you have a board of how many now? What is your total?
7 plus 1 non-voting.
Fully constituted, so 7, we'll say 7. So so suppose 4 of you, someone walks in, you're like, shoot, 4 of us know this person. How, but you still have to move forward with the case, right? With 3. How do you get a quorum? Well, there is a quorum exception to COIA. How do we ever get a majority vote if members disqualify themselves from voting subject to COIA? There is a savings clause that allows the remaining members of a body to constitute a quorum to take action if disqualification under the act would result in fewer than the number of members required to act. So remember, Bill talked about 2/3 vote needed in order to issue a subpoena. But if you can't get 2/3 of 7 because 4 of you have recused yourself, the remaining members, you can count 2/3 of who the remaining members are under the savings clause. So you can reduce what it requires to get a quorum if conflict creates an inability to get a fully constituted quorum. Yeah, and under that exception, they have to be actual disqualifications for conflicts, not just the fact that you don't have members present. Like there've been many times where we kind of sat around waiting to see if folks would show up so you could get a quorum. That does not apply. That's not a quorum exemption. It actually has to be based on conflict of interest. Disclosure forms. PCOB members are not required to file disclosures unless city council so designates, and city council has not so designated, and you should thank them every time you see them for that. Violations, these are the violations for Conflict of Interest Act. You can all read those. What if you think you have a conflict? Ask, and this is probably more than you will have to deal with, but you could ask for the written opinion of a local Commonwealth's attorney, or you could call the COIA Advisory Council. Generally, you all would call the city attorney, or you'd call me, and we'd talk about it and maybe talk about to the chair, and a decision could be made there. But this is really deals more with state officers. Questions? I told you, that was 64 slides.
I do have a question so you're the attorney of record for this body?
For this independent counsel, and the way the ordinance reads is all of the business of PCOB, the legal questions can be resolved by the city attorney. However, the board has independent counsel because there may be times when the city attorney has to look out for the interests of entities that would be adverse to PCOB, maybe the police department, maybe an employee who is a witness that needs to be compelled. So you all have local.
So does that mean our first place that we go to is the city attorney and then?
It really,
We
Bill
fought
can
that, we
answer
fought
that.
that, we fought that out.
Yep.
And I think that as a general, as it's good practice to do it that way. However, she is our lawyer. She can advise us on any issue if it is necessary.
And the
Because I could
practice-
imagine in this body, there'd be a lot of instances where you might not be so comfortable going to the cities.
Well, timeliness is an issue as well.
Yeah.
Susan, and that sometimes.
Oh, God, yes.
Availability of the city attorney is limited. by
And is
their-
there even a
Oh,
city
yeah.
attorney now? Is there?
No,
No.
we have
No, we
access
still don't have
to
one,
that.
right?
One of Lisa's,
Well, and in practice, the city manager has authorized you all to come directly to us.
Yeah.
Right? They have not said, hey, oh my
No.
gosh, look at this independent counsel budget. You all need to go to this. They've said, yes, we've given you independent counsel. We want you to use that counsel. And it has really streamlined things, I think.
and boy, Pam and her predecessor really get on it, which is
We
a
we
benefit.
try to be like
Really?
responsive because we know that you all, your business is fast moving and delay kind of clogs up your works. So that's all I have. There's a
Thank
lot.
you.
Right.
So please use this as a reference that has more information than you'll probably ever need. But if you ever need another copy, just send me an email. You've got my email address. Happy to respond. Oh, but as a matter of, just in terms of management of billing, if any of you ever have questions, it's better that you shoot them to Bill so that Bill can let me know, because if 7 of you are sending me email and then, and I start digging into all these legal issues, and then Bill sees that bill and he doesn't know that all these questions were coming, that could be a problem. So we always like to say the person who is going to be reviewing the bills needs to know every time you have a question that needs to come to the attorney. So your question should come from you to Bill. And if Bill can't resolve it, Bill will send it to me and I'll interact with Bill instead of 7 different people starting the clock on my bill.
Great. Well, that was good. The savings clause, I had no idea that there was a savings clause, so
Yeah, that's good to know.
that was very useful. So if you will stop sharing, and I will go back to
Stop
sharing, and I just have some brief notes. I think we'll be out of here before.
Did I stop sharing? Stop sharing.
There you go, my turn.
Yeah, 60 miles per hour.
Okay, now, these following slides are, I think, totally incomprehensible. What they're meant to be is sort of an outline of the complicated stuff that we do. How do we process complaints? How do we, plan and execute hearings, investigations, and make disciplinary recommendations? Much of the organizational and procedural work that goes into these will be done by our executive director, which is very, very good. And as you can see in each of these slides, I put a reference to the various directives, the procedures, which I'll be sharing with you, along with a lot of other things. The first one is about complaint processing. The main important sort of take-home lessons here are one that under our new ordinance, when a person files a complaint, they can ask that we investigate it or they can ask that we not investigate it. And then you, if they ask that we investigate it, the executive director, the assumption is that a legitimate complaint will be investigated. The executive director will do a screening to make sure that it's timely, and that it is something that it's within our power. It reports something that the Charlottesville police did as opposed to the Albemarle police, and all these other hurdles that it has to go through. If the recommendation is to investigate, the executive director then is going to draft a recommendation, which allegations does he or she recommend be investigated, and they'll put together a draft investigation plan. And the investigation is on the next slide. And then the investigation actually happens. It's actually done by the executive director or an independent investigator. If the recommendation is not to investigate, that goes to a board vote and we agree or don't agree. In the case where the citizen does not want us to investigate, and that happens actually because we're not, we're getting up in their business, and some people don't want a bunch of strangers, dealing with with something that's, one of the worst moments in their lives. And so they decide that they'd rather have the internal affairs group do it. If internal affairs is selected, then they make the decision whether to investigate or not. They do the investigation and they run. And that's the only thing that the public sees if an internal affairs investigation is done, is the closure letter. Actually, the public doesn't see it. The complainant sees it. And if they don't like what's in the closure letter, they can ask for a review, which we'll talk about in a couple of slides. We have the power to do independent investigations. As I said before, investigations can be triggered by citizen complaint or an incident of serious police misconduct or alleged serious police misconduct. It is up to the executive director to define the recommended scope of the investigation. Under our ordinance, the executive director may conduct the investigation. And let me just say that the executive director candidates that we've interviewed were extremely well qualified to do this. And I'm very hopeful that the city council will accept the city manager's recommendation. But in any event, the executive director can lead the investigation, or he or she can engage in an independent investigator. Of course, that's an issue. We have to line up independent investigators, and we've never done it. The choice as to who actually does the investigation depends on the workload and the complexity, and it's determined by the executive director with the approval of the board. Obviously, we have to comply with all applicable laws when we plan the investigation. The first thing that our executive director needs to do when he or she arrives is to write an investigations manual, which will specify the required elements of investigations. Hopefully, this will include sort of templates that he or she can just pull elements out of and start filling in. We have a rigorous schedule. An investigation has to be completed within 75 days. That's very demanding for a serious complaint. So there is an allowance for someone to ask for additional, the investigator to ask for additional time with justification. At the end of an investigation, we get an investigative report. The investigative report summarizes witness testimony, all other evidence that's been received from the police, all other evidence that's been gathered, and it includes recommended findings for each allegation. So the investigator or the executive director will say, well, you know, in the case of violating the code of conduct, we find that's not sustained, whereas race-based policing, we believe, should be sustained for the following reasons. And then the report provides the basis for our board's hearing or for our actual actions of a particular case. As I said before, if the individual is not happy with a closure letter, they file a review request with us. Again, as for the citizen complaint, there is kind of a presumption that unless there's something seriously wrong with the review request, we'll go forward and investigate it. After we decide to review, executive director will produce a summary of the evidence for us, and we are allowed, we may, and hold a hearing on the basis of the available information. Again, the presumption, sort of the intent was that any complaint of any complexity or seriousness would probably merit a hearing. After we hold our hearing, we can make 3 possible findings. 1, the investigation by the Internal Affairs Department was okay, was satisfactory, complete, unbiased, and their interpretation of it, the second part of your analysis, was appropriate as well. We can also agree that the investigation was complete, but that we don't concur with the findings of the Internal Affairs Department that, for example, a particular allegation should not be sustained. And the final finding that we can have is that the investigation is incomplete or unsatisfactory. And at that point, we can either send it back to Internal Affairs, or we can have the option of doing our own independent investigation. This is so far, we have never gotten anywhere near that far on our procedures. So, how frequently that's going to happen, I just can't tell. Hearings. Everything we do is a review hearing. It's either reviews a review request, or it reviews a completed investigation by our executive director or independent investigator. We have notification requirements before we hold a hearing. We have a pre-hearing conference to work out details, procedural details, what actually happens during the hearing. Under our ordinance and procedures, the hearing and the pre-hearing conference will be presided over by a hearing examiner who is something like an administrative judge. And as Susan knows, we've been trying to find people who will be willing to serve in that capacity and have sufficient qualifications. It's not a trivial task, but hopefully we will succeed fairly soon. The plan approach to any public hearing is that would hear statements by the executive director summarizing the investigation, the parties, whatever witnesses parties wish to bring. Questions by the board members, questioned by the parties subject to relevance check by the hearing examiner, so that we're not going to be, people aren't going to be badgered or going to be asked irrelevant questions, or, you know, what were you doing out there at that time of night? You know, I mean, it's not going to happen. We then deliberate, and we can do the deliberation at the same meeting or at another meeting. And a public vote on findings, excuse me. All of the findings that we make are based on the preponderance of evidence, which is, it's more likely than not. It's what a reasonable person would conclude is true based on the evidence. One of the training webinars that I'm recommending for you is got a good definition and discussion of preponderance. When we're done with our hearing, we need to report publicly in 30 days. If we are investigating, if we're reporting on an investigation, our findings are we didn't sustain any allegations, that we sustained one or more allegations and give the basis for that decision, and that one or more sustained allegations is or is not serious breach of police procedures and guidelines. Because if it is a serious breach of police procedures and guidelines, then we can make a disciplinary recommendation. And then again, and this is another, this is actually a meeting and not a hearing. The procedures running up to this meeting are described in PCOB 11. It's involved, again, notification. The executive director talks to the individual supervisor and to the chief of police at their discretion, to the complainant, to the witnesses. And during the hearing, we first hear from the executive director about the allegations and why they are serious. If the chief or the complainant or any witnesses for any party wish to make a statement, we can hear that. We can accept written statement from the subject officer. We also are free to consider prior sustained complaints against the officer. Although in judging actual guilt and innocence, I don't know that that's very probative. We deliberate and we vote on recommendations for judgment. Now, the recommendations that we make have to be consistent with the Charlottesville Police Department's disciplinary matrix, disciplinary regulations. I have a catalog of things that you can do wrong with a gradually increasing degree of severity, and then prescribed corrective and disciplinary actions. And in many cases, these are broad, very broad categories. It depends on whether it's a repeated action, or it's the first offense. So whatever we do, we have to cite chapter and verse of the disciplinary matrix. It's a class B offense, and for class B, the offense, the first class B, the offense is the corrective action is X or Y. It does not take a huge amount of judgment away from the chief of police. I don't think it locks them in very tightly because of the way that the discipline matrix is constructed. After we make our recommendation, the chief of police can implement our recommendation, or within 30 days, provide a written statement as to why they did not. So we can't, we don't have the power to inflict a specific corrective action or disciplinary action on a police officer, we can strongly recommend. So again, I suggest you look at the, as priority for moving forward on training. You look through the various, you familiarize yourself with the operating procedures. So, any questions on any of that before I just, yeah.
I had a question on the last slide. So for the disciplinary matrix, is that something that our ED will hold, or will we receive a copy of what that looks like?
That it's a general order, which is available on the police website.
Okay.
It's actually two general orders, part 1 and part 2.
You said it's broad. So does it is it like clearly stating though, like what falls under what category?
One of the answer is not very. And one of the questions that I've always had about internal affairs investigations is whether the allegations are the right allegations. So if they include something that's less severe when if it's rudeness when it was in fact force outside, of guidance, for example. And so that is one of the things that we'd be looking at. If we do an independent investigation, the executive director will recommend what allegations to make on the basis of facts. And then it will be up to us to agree or not agree with the specific allegations. So.
And I will say that just listening to this sounds overwhelming, and the flow chart look like a lot, but makes so much more sense, right, than it did. Like Bill was able to achieve some sort of more streamlined clarity in the revision process of the SOPs. And don't think you have to like read all these SOPs and know every procedure, because once you know which type of investigation or review you're dealing with, you'll just read that one SOP or the 2 SOPs related to that and acclimate yourself to it within those 1 or 2 at a time. And then eventually you'll be accessing you'll sort of have access to all of them and be using all of them.
Yeah, and I think, again, I think we're all sort of committed to learning more as we go. So, we have this short-term requirement that I want to be able to certify to the mayor, that by the end of May, we've all had, 8 good hours and are sort of reasonably cognizant of the broad issues associated with the board's functions. But again, I think we'll continue to have trainings in our meetings on different topics. Now, what I have here on this slide.
Can we go back for just a second? Can you go back a couple of slides to where we're accepting a complaint from a person, from a member of the public directly? I'm trying to picture what this investigative process looks like. This isn't related to internal affairs though, right?
This is,
So
okay, this is a review request.
No, go back further.
Okay, so we want to say.
So now we've got a citizen who's come to us and made a complaint and they want us to investigate.
And has not gone to internal affairs.
Correct.
Yes.
So the ED is screening the complaint.
Yes.
Which is presumably, I don't even know what a complaint looks like. Is it a form that somebody fills out? Okay, so they fill out that form.
Ideally, it's a form, but it could be, in any.
But the ED at that moment is not interviewing witnesses, interviewing the police at that stage. Am I correct in saying that?
That is correct.
They're just reviewing
he or she will certainly be in contact with the complainant.
Okay. So maybe they'll interview the complainant, but they haven't interviewed witnesses or anything. So then it goes, they say, okay, I think there's something here. I'm going to take this to the investigative stage. And it says the ED or an independent investigator conducts the investigation. Are we sitting there listening to them interview witnesses and saying, hey, we have questions or?
No.
Okay. So we're almost more like a jury
Yeah.
that's then
Precisely.
evaluating.
We are fact finders. We are only fact finders.
Yeah,
Right,
and your
but we're
executive
not-
director is your sort of your hands and your feet.
That's
and
our
your ears and your
prosecutor
eyes.
per se.
Yes.
That's our prosecuting attorney. Okay.
Yeah, we're a jury. That's a good ad. That's perfect.
And presumably the the ED is kind of playing the prosecutor and the defense attorney at the same time, really,
Ideally.
right?
Yeah.
Okay, so then when they come to us, they'll come to us with some written summary of what their investigation was, and that's what we're reviewing?
And we should have access to all of the evidence from the independent investigation.
And are they
So
required to record witness interviews, or
Yes.
is it just making notes? So presumably, we have the opportunity to actually hear the witnesses talking about.
Yes.
Okay, and then this is not one that ever goes to a hearing with an outside examiner, is it? Or if we don't, let's say we don't agree with the ED's conclusion.
Then
There's a specific, I have the SOP
Yeah,
right
sure, go
here.
ahead.
Can I read that? So the executive director's recommendation to decline an investigation, is that what you're asking about?
Yes, yes.
So after a complaint has been screened, the ED recommends that an investigation and the ED recommends that the investigation be declined. The ED shall so advise the board in writing stating the basis of his declination recommendation. In making the recommendation, the ED shall consider the following factors, and it lays out the factors. In cases where the ED makes a recommendation to decline investigation of a complaint, the board chair may accept that recommendation and notify the board of such decision. If two or more board members object to that recommendation to decline, the board chair shall refer the matter to the full board for consideration and vote at its next regularly scheduled meeting. So, but
if we don't like it, we all agree, we don't think you did a good enough job, ED. We now want a hearing, or we want you to go back and interview the following witnesses, or it's
yeah,
not.
we can certainly ask.
well, and then here it even clarifies, it says, if a majority of the board votes to not accept the ED's declination recommendation, the chair shall direct the ED to proceed with a full investigation of the complaint. So then you, instead of, because what he or she has just done is screen it for you and say, there's nothing here.
Okay, well, let me go to the other one. They've determined there is something there, and they conduct their investigation. They've concluded their investigation. Are they coming to us and saying, this is what I recommend you do, board? Or are they just saying, here's the facts, you figure it out on your
We
own?
recommend.
And then here, and this is what the SOP tells you. Options after the screening is complete. The ED shall screen every complaint that is received and shall take any of the following actions. Recommend declination, consult with and refer to the Commonwealth's attorney if there's something that needs to be referred out. With the agreement of all parties, refer the complaint to mediation. Refer the complaint for an investigation to be conducted by the board pursuant to the complaint and investigation operating procedure, or refer the complaint to the police department for investigation because it falls outside of the authority of the board to investigate.
So we have, and so there's there are two. Yeah, so those two operating procedures lay out the steps for the actual investigation.
And then presumably, if they do this they do their final investigation, they make a recommendation, and we're like, we don't think you really did enough in your investigation, ED. We need you to go back and do a little more. We have the authority to direct the ED to do that.
Yes, the ED has really no independent power except that derived from the board.
Okay.
ED is a support staff.
Now, jumping over to the internal affairs side of it, the other type of complaint. The hearing that happens when you finally get to, let's say we get to a hearing stage, we say we need a hearing. This is a public hearing in a Supreme Court?
No, probably in a room like this.
Okay.
In a room like this.
Okay, and we're present during that.
You all are this is your show. You are the tribunal.
So we're asking the questions or the ED's asking the questions?
You're asking questions.
Okay.
Yeah, and again, we've actually had some real Donnybrooks about how, what the hearing examiner's job should be. I'm sort of that they advise us that they are a presiding officers. So
They're a judge.
They're presiding officers. Yes. So they decide who asks questions and when, and they can screen the questions before they're asked.
Okay.
And there's questions about due process and confidentiality and the officer having to disclose something that would be harmful to the, so I mean, it's tricky.
And do there,
You attorneys would advise us there, but I mean, there are due process considerations. We don't have free reign.
and do the Virginia rules of evidence apply to these
No.
hearings? Okay.
Well, the Virginia rules of evidence are a guide.
You're right. They're guides. They're sort of an overlay. So like hearsay is admissible or not, depending if the board says no in a particular hearing or objections are not, kind of ruled upon in the same way that you might expect, but it really depends. It's really kind of more
Free for all, a
informal.
little more free for all.
Right.
And are you present at, like, if we want an attorney to be
Oh,
there to
God,
say,
yes.
hey, can
Oh,
we
yeah.
ask these kind of questions, or is it appropriate to?
Yep.
Yep.
Then you would be there to advise us about those rules of
I would be there
evidence.
to advise the board, and then if the board, and the hearing examiner is there to sort of guide the process.
Yeah, and in fact, the hearing examiner is the first barrier to somebody asking a nasty
An
question.
improper question, okay.
If the board thinks the question should be asked, we can overrule.
You can overrule the hearing examiner, yes.
But I'm expecting that's not
Rare.
happen very often.
And it will be up to the will of the board to decide, how much authority you give to your hearing examiners, right? Because you can, I mean, their duties will be laid out by your SOPs, they're already laid out by your SOPs, but the board ultimately has the power to decide,
Now,
if the hearing officer is doing it right or doing it wrong.
Now, I'm sorry, I'm asking so many questions, but now where does the public fit into all of this? Because we are now sitting here with the ED, they're giving us their interpretation of what they think the facts are of the case. The public is hearing everything. And then they have an opportunity to say, oh, board, I don't like what you're doing here, or ED, I don't think.
You all are the will of the public, will of the public body. You speak for the public.
But they have 3 minutes or so to
At
state
the
their
end of
opinion?
after we've taken our votes. and
After we've
recommended
taken
that,
our
Public comment. yeah.
Okay,
Just
so the
observers
public,
before that.
okay.
I'm gonna say that they can lynch us after we.
That's what I was getting at one point. They can lynch us.
That's right.
Sorry,
Somebody will be unhappy with the outcome.
sorry for the trigger
I
word.
was just- I can
Yeah,
imagine.
But yeah, all of your questions are really good questions and issues that
Excellent
we sort of we're working through when we write as part of the SOP and say, ooh, well,
Yeah. See, it raises a bigger question here, and that is, can we pull this off? Because this is complicated.
It is complicated.
We're amateurs, and it took a long while to convince the city council that this was worth doing. And so what I'm very much hoping is that with the new board here, with the new energies that we have, we will be able to move forward, rather than just fall back, into ineffectuality. Turns out that a major factor in the life cycle of oversight organizations is that they're short. That after 3 or 4 or 5 years, people just go, what the hell? Because they sort of lose interest because it's hard. And because, as I say, some people in the public lose interest because they don't see what's in it for them. You know, long-term changes in quality of policing, you know, it doesn't make them whole for when the policeman knocked them to the ground, you know? So.
You will see that the interest in what you're doing ebbs and flows with what's going on in terms of policing in your community.
Yeah.
If you have a flashpoint incident, oh, you will become so important to the community. Everybody will want to know, what are you doing? Why are you doing it? What? And then if everything's been calm in the policing community for a while, then that sort of will fall back. And I will say that just in looking at this PCOB, just oversight boards throughout the country that have been in existence for, 20 years. No one has, this is the first one I've seen that's taking on as many aspects of oversight as you are. You have an auditing function, you have a disciplinary review function, you have a review hearing function, you have an investigative function. Most oversight boards might take on one of those things, or maybe even two. Maybe they audit and investigate, but they don't have hearings. Or maybe they have hearings and investigations only, but they don't audit and monitor and do discipline. You all are taking on sort of every aspect of what oversight boards historically have done in the country. And that's a big,
Ambitious.
a big ambitious bite that you're taking. And so.
Well, but I should also point out that the framework within which a lot of these well-established boards were founded was a legal, legislative, law enforcement framework in which there was a lot of resistance. And so, Fairfax County has had a review function for a long time, but mostly it's an advisory board. And I've hit kind of a sweet spot in legislatively where people are willing to move forward and take a rather aggressive stand. We've got a progressive police chief. I'm really hopeful we're going to have a very impressive executive director. So I'm, really looking forward to getting this thing off the ground and setting the example.
Susan, there are folks in the state that feel like Charlottesville is really the prototype and the canary in the mine in some ways for this whole model, because it's probably the most robust model, certainly in Virginia and maybe throughout parts of the country that I've seen. Pam, you might know better.
No, I haven't seen one that has all components.
Which is
I mean,
both-
that's a little scary on
I
one
was
side.
saying,
It is scary.
It's exciting and it's terrifying at the same time.
Well,
Exactly.
and as you go through, there, as Bill said, there are life cycles of oversight boards. So there, who knows what the future holds, but I can tell you that I'm showing my age. In the 90s, when I was counsel to the police department in Detroit, Michigan, they had what was called a disciplinary review board. That is the only oversight that police department had, which is frightening given the degree of problems Detroit had in policing at that time. And the only thing that oversight board did is review the recommendations for discipline. And that was a sitting body that if an officer was drunk driving in his vehicle, the chief would issue a certain discipline. That discipline would go before the review board, and the review board would weigh in as to whether the discipline was appropriate. And they had the ability to overrule the police chief's discipline and impose and ask the mayor to impose certain discipline. But that was a very narrow function. So I can't, and that was chaos. When I tell you it was chaos, we met every week and had multiple cases every week on the docket. And that was chaos. And that was one singular component of oversight. So when I tell you that you have some aspect of that and others.
Well,
So-
I'll tell you one thing also. Again, another interview story when we were interviewing one of the candidates for executive director. And she was talking about, that she had been working internal affairs in a large eastern city. And, you know, she had at any given, they had maybe 1,000 to 2,000 complaints a year. And at any given time, she had 50 or 60 on her desk. And she asked what our, you know, what our workload was. And we said 30 per year.
Well, but you balance that against the number of arrests that they have.
Yeah. No, but so the point is that in a certain sense, at least the workload is not going to choke us.
So what is the recommended procedure if we are approached by members of the public who might not be happy with the way things are going on?
Say, yes, ma'am. Sure. Oh, yeah.
Thank you for your feedback.
That's our job.
We've had it, believe me.
People approaching you outside of this, outside of this room.
Emails, phone calls, confrontations. I've had them.
So I'm just trying to figure out what to be prepared
But I think the
for.
worst of that is over. I think the worst, honestly, that was during a period of real transition, of trying to iron out
Instability,
the
yeah.
ordinance, a lot of other controversy. It's really quieted down. It's quieted down with a new chief.
Well, until something happens, that's.
I know, but it's also quieted down with the new city council.
Mhm.
I mean, there was a lot more flame throwing before some transitions occurred within city government. So I don't know if others have felt that. I haven't been approached in 6 months.
I think it's gonna matter of the complaint that you're dealing with. It's gonna
Well, that
determine
could
that.
too.
Yeah, no,
That they-
just on a more serious note, we have an email box. I mean, you know, the board has an email box. We answer all our emails. So it's really important. And we have public meetings and not many people come to them, but if they would come to public meetings, they could be heard. I don't know what else to say. I don't think
I
it's
understand. I
a
understand.
physical, I
I'm
don't
just
think
trying
it's a
to-
physical threat to your well-being.
No.
Yes.
How do you determine, I know that you probably have a lot of complaints, so how do you determine which complaint to look at first? If this takes a long time,
Well, we right now, until we get an executive director, there is nothing in our queue. So we can't start until we have an executive director. And so at that point, we will start with the first complaint that comes through the door. And then we'll knock on the second complaint that comes through the door, and the third complaint that comes through the door. There is no reason why investigations of more than one complaint can't happen in parallel. So, and again, if we're going to have 30 or 40 or 50 complaints total per year, and say 10 or 15 of them can go to mediation, that's not a lot.
And some may not get past the ED. I mean, you know, they won't rise to the level of coming to us. If they're frivolous or.
And the board and the ED have the ability to hire investigators if you should ever have such a workload that you've got so many complaints that the ED does not have time to do all of the auditing functions and everything else they have to do and investigate. There is a provision in the SOPs and the ordinance which allows you to hire investigators to support the executive director.
Now, you said we have meetings once a month every
So
Thursday,
far,
every
so far.
second Thursday. Is that presumably when we're dealing with each complaint, or are you anticipating
well
there'll be
be.
additional meetings during?
It
the
may
course?
well be that we will want to, when we have a hearing on a review request, we'll want to hold a special meeting.
And I have communicated on multiple occasions to the mayor and city council members that we are volunteer. Just like to remind them that they're, you know, we're not doing this for the big bucks.
So yeah, no, I think that's, I mean, yeah, and it's going to be a challenge to see. I mean, we were hoping that the first, that the first complaint that we dealt with would allow us to crank through all the machinery. And because of the particular circumstances of that complaint, it didn't work out. So we're still going to have to
We've had mock
Be a little
hearings.
tripping on the way.
We've had
Sure.
mock hearing, we've
The
had
board
mock
did
hearings.
did conduct mock hearings to sort of, and I think that was informative.
It was informative, but it
Very
also
informative.
showed us how challenging the process can be. Would you agree, Pam?
Oh,
mean, just
yes.
from
I
looking
mean,
at-
that seems to me like a really good training tool.
Oh,
And it was
If
it was
can be
invaluable.
completed with all of us here, because I mean,
we should
you know,
maybe
to me,
redo
and I
it.
don't think, I think everyone in this room will agree, our credibility is gonna be based upon our professionalism and
Yes.
our calmness and our compassion and
And our neutrality.
our neutrality and our impartiality. And I think having moments where we're tested in a training environment perhaps will better prepare us for the real
Sort of like a
world.
stress test of the
So
process.
if there's
So we
a
have a
way
mock-
to offer
Well,
that
we
to
have a
us, that
mock
would be
hearing,
useful.
we had a mock hearing on a case. And the police actually, the police built a, well, they used a long expired case. And
Can that be repeated?
It would be interesting to see that now that we have a fully constituted
board.
set of SOPs, you know,
Oh,
that would be interesting to see how that would play out now.
absolutely, and now I would know what not to do.
And at the
also
time that
looked
the
at a-
mocks were done, the SOPs again were sort of in development in terms of, I mean, there were SOPs, but they were sort of the skeleton outline of what the board wanted to do, but now you've got fully ratified SOPs and there's no sort of misunderstanding about which ordinance is effective or which SOPs, you know, because there was so much uncertainty about even which ordinance the board was empowered by at the time that those mock hearings were done. So now
That's good.
everything's clear about what the governing ordinance is as well as what the SOPs look like. So it would be interesting to see a mock.
We spent,
Because, you know, I know just from experience, it's a hearing
it's just-
is stressful enough even for a professional who's done it for 20 years. So for a body of people who haven't had that experience, it's going to be a stressful experience. And so preparing us with that kind of training, I'm just requesting that maybe it be considered, because I
I'm
think.
just, well, like I say, one of the things, I think with a realistic case, well, and a highly qualified and skilled, that will be extremely helpful for us. A lot of the questions, you know, when the executive director presents the results of the investigation, that will answer a lot of questions.
Might be a good, you know, sort of first exercise for your new ED.
and I think to Bill's point, I mean, we don't want to put too many demands on our budget. I mean, these things take time. And we just don't, I hear your point, Susan, but I think that, you know, it's.
Preparing us,
asking a
though,
lot.
will eliminate some of the stress that will come.
Yeah, no, I think that mock hearings, perfect. You know,
One we did, one of the cases was actually an Alexandria case, the man in the street.
yes, well, that was an interesting
It
case.
was, and I don't know if there's a video of that.
We had the
Even,
video. We had
even a video
of the-
of seeing this process.
Yeah, there was a
yeah.
body cam. Oh, did we record the mock?
That's what that's
I'll
what.
have to check, I'll have
I
to
mean,
check.
if we did it, we will with you watching, you know,
Yeah.
because we asked questions and we went through it and we looked at the body cam. It's a fascinating case. And then when we got done, then they told us what the actual outcome was of the PCOB in Alexandria, and they ruled, which I was Fairfax, it was Northern Virginia. But anyway, I was a bit surprised about the outcome, and I won't give it away, but it was really a helpful exercise.
Okay, well, I'll definitely, that's a great idea. So we're at 4:00, give me just a short, few more minutes here. This is sort of what we have covered and what I recommend we cover to become, to get our merit badge to first, for kind of the basic training. You know, at our last meeting, we talked about the history of the board. You presumably read the highlighted, the ordinance. You presumably presumably have seen the NACOL Police Oversight 101. We've done Graham versus Connor. We've done the nature of complaints, all the things that are not shaded. What I recommend is these other entries that are shaded be done over the next month or two. I guess it would be two months since you have now been on the board 1 month. So maybe just familiarize yourself with the operating procedures. We have a training session on investigations, which we did in March of 2021, which I will give you the URL for. It was extremely useful. Jason Rector, has been doing police oversight for 40 odd years, was the leader of that. He told us all about what is a good investigation and what is a bad investigation. And you can skim past all of the other housekeeping items at that meeting. Jason Vector wrote a very interesting article called "Investigating Citizen Complaints." Why it's different. I'll give you a copy of that. And that sort of is the kernel of, the basic idea. Why do you have oversight investigations? What can and can you not accomplish? What are useful techniques? Why are people generally dissatisfied? But that's a fairly short article, and I would suggest you read that. There are 2 NACOL training webinars. First one is making factual determinations, which is good because it has discussion of preponderance of evidence. And it's exactly what we would be doing when we have this hearing, essentially, our hearings. And finally, the strategies for successful mediation. That's a two-part webinar, the first of which is about the New York mediation, which is much more close to what we are thinking of than the second part of it, which is another city, which I forgot. And I'm just thinking that if it would, while it would be great for us to have stop with that thought for a moment. I think if you, get most or all of this done in the next couple of months, I can certainly be able to tell the, city council and mayor that, you have participated in a conscientious way in the training, and that we're going to continue to do our training and possibly have a mock hearing. And as I say, I'll distribute all of these to you after this meeting. So that sounds reasonable or not reasonable. Any questions?
Maybe a million, but.
So we are, this is a public meeting, so we therefore are required to have a public comment period. Do we have any attendees? Would you poll the attendees?
All right, I'm just gonna read through the script really quick. If you'd like to speak to the PCOB, please click the raise hand icon in the Zoom webinar. Press *9. Each speaker will be allowed up to 3 minutes. And it looks like they are raising their hand. All right, Madeline Conger, you are on with the PCOB. Can you hear us?
Yeah, I just wanted to let Bill know that an alarm was going off on his computer for the last 10 minutes, drowning out all other audio. I don't know if it was audible in the room,
Hello?
but it was his computer audio coming over the Zoom, and it was just like an alarm clock sound. Can you
For
hear me?
another moment, see if we can make a connection.
Can you not hear me? It's because the audio is coming through Bill's computer. You can't hear me at all. I think the reason you can't hear me is
No luck?
I think the audio is coming through Bill's computer, which he has muted.
Madeline, I'm not sure if you're speaking, but we cannot hear you.
Is there a chat she could put it?
Yeah, if there is a chat function or certainly an email to me or the board with the comments. Appreciate that.
Madeline, if you'd like to talk, I did give you permissions to type in the chat. Oh, there we go.
She's hearing the audios or audio.
Nothing but loud ones in Bill's computer.
Bill's computer.
Ah,
I don't know why that would be, because it's. Especially since you're muted, Bill.
I'm sorry about that.
Try this again. Add them. Oops.
now can you hear me?
We are still not able to hear you.
It said the host muted you. I think you muted me. I'm unmuted on my end. You still can't hear me? You can't hear me. Nothing?
The same as the audio was playing, my alarm sound. So that's it for me, but this is an issue to resolve for future meetings.
They will do.
Okay.
adjourn? Second. Do that by acclamation. No objections? All right. Thank you all for coming.
Thanks, Bill. That's all.
Oh, it looks like yours.
Yeah, so I was like.
No.
Wait, did we get those? Did
Yeah.
we give
Yeah.
those? Oh, I didn't get one of those, so maybe that is mine.
Oh,
I
it
didn't
goes
even
with
know
your
it.
computer. That's what
Oh, I was wondering, because I thought, that doesn't feel very safe to just have it holding this like this.
They should have a charger in there.
Thanks, Pam.
Thank you. Good
See
good to see you in real life.
Is it in this, like, there's a bag.
Yes.
Back in person again. Happy to always come down here anytime.
Hate to make a drama.
No.
Forever, but-
We're going to. Let's keep going.
Oh, wait, maybe this pocket.
Saturday?
Yep. I'm good.
Okay, good.
Well, you know, I was
I was about to say, oh, God.
I'm home alone, so, you know, I'd be doing laundry.
See you.
Good to see you.
Thank you, Bill.
Well, thank
You
you.
have questions that I don't even know
Sure
how
that-
to ask. And you ask, and then after you ask.
This is not
because-
gonna be easy.
I can't imagine
Don
actually
Quixote
But I
is
applaud
one of
us
my,
making the
No,
effort.
and I, this is why we need this.
Just tilt it window.
Because we
All
need
right, well, there you go.
mediators, we need lawyers, we need
So you had
psychologists, we need,
Yeah,
know,
there's a
Yes,
lot of-
yes, gonna get on the
it's
road.
complicated.
It's just the procedure itself is gonna, I
Yeah,
think
but
we're
thank
gonna
you very
trip a
much
lot.
for coming.
And that's
Okay.
why the more training that we have in preparation for that, the
Nice
better.
to see all the
prepared.
new members. I'm excited
I
about.
don't know,
what you
ask
guys
Bill.
do.
Validation.
Going.
Do we validate it all? I don't think so.
I thought we did, we used to,
Parking?
yeah.
Yeah.
If you do, I don't know anything about that.
We used to, Bill, didn't we?
I do not, recall. I think
Tricia, if
in the
you,
past we did, but
when we present it to City Hall or something, to the
when we,
council clerk's office, she'll get you paid. I think if you submit to the clerk of the council bill, they'll
yeah,
take care
that'd
of it.
be no problem.
Yeah. Thanks all. Good to see
Oh,
everyone.
did you have to pay